Saygıdeğer katılımcılarımız, fuayede bekleyen değerli konuklarımızı salona davet ediyoruz. Sempozyum programımız çerçevesinde ikinci oturumumuz birazdan başlayacak. Dikkatiniz, özeniniz için teşekkür ediyoruz.
Distinguished guests, could you please take your seats? The second session of the symposium is about to start. Could you please take your seats, ladies and gentlemen?
Saygıdeğer katılımcılar,
Distinguished participants, the second session of the symposium shall start within a few minutes, and we would like to kindly ask you to take your seats.
katılım
Distinguished participants and distinguished guests, ladies and gentlemen,
Katılım öncesi mali yardım programı çerçevesinde kabul edilen ve Avrupa Birliği, Türkiye Cumhuriyeti ve
this is a project co-financed by the European Union, the Council of Europe, and the Republic of Turkey under the IPA program. And we have now come to the second day of the International Administrative Judiciary Symposium. The open remarks and with the first session, which is the consistency in judicial judgments. Today we will have two further sessions. The second session is the reducing of the workload in administrative justice. I would like to invite the acting president of the Council of State, Mr. Hasan Güzeler, to moderate the session. And I would also like to invite the speakers of this session for an administrative procedure law in Turkey. On the topic of pre-litigation alternative dispute resolution methods in the Turkish administrative justice system, Associate Professor Dr. Nilay Arat from Kadir Has University. And recommendations on alternative dispute state, Dr. Hasan Gül is the third speaker. Distinguished guests, as yesterday, we have a 20-minute break in the session as well, and we have a Q&A where you will be able to the session, Mr. Güzeler. Distinguished Acting Chair of the Council of State, distinguished colleagues, we are now starting the second session of the International Symposium. Distinguished Professor Bahtiyar Yılmaz has been working for long years in Gazi University, which was the old name, and with the new name Hacı Bayram Veli University. Context. And the topic of today's presentation is the need for an administrative procedural law in Turkey. Any kind of action of the public administration, the fact that the procedure is identified for these actions is important for a vision of a state of law. And this is going to provide, and it will also eliminate the unnecessary litigation process. In our country, all the actions and transactions of the public administration is not governed by a general public procedure law, the administrative procedure law, and unfortunately the draft legislation that was prepared for administrative procedure law previously have not been enacted. And I do believe that this loophole in the legislation is trying to be met with various regulations and bylaw. The public administration and ministries that issue the secondary legislation identifies what is the criteria for the administrative procedures and which body is going to govern this. The administrative procedure law prior to this is also important in relation to the procedural review. And the fact that the criteria for an administrative procedure law are not foreseen for by the legislation, there are certain things that make the task of the public administration difficult. Without further ado, I would now like to leave the floor to Professor Dr. Bahtiyar Yılmaz. Thank you very much, Mr. Chair. Distinguished participants, unfortunately, I did a presentation on this topic previously as well, and I need to focus on the need for an administrative procedure law. Let me mention the following. In this project, we had an assessment meeting last month, and in the meeting with the auditor for this project, there was a mention that the administrative aspect, my distinguished colleague who was doing the interpretation of this, when I said I have been working on this since 1995, and the colleague who interpreted said, if you allow me, I will not mention this. It's actually true that since 1995, there have been various commissions established to identify a general administrative procedure law, and for one reason or another, this did not yield to any output. And unfortunately, this is why we do not have a general administrative procedure code in our country, and this is an important problem for us. Let me mention the following. As you know, recently, there have been a lot of reforms in the field of justice, and there have been certain regulations that have been issued in the administrative law field. And when we look at these, this has been more or less on the reducing of the workload of that. The President of Council of State indicated that the annual case file number declined to 96,000, but even this figure, when compared with the practice in France and Germany, is a very considerably high figure. In that case, is the resolution to reduce the workload and accelerate the process of administrative prosecution to maybe resolve certain conflicts in a much more accelerated manner, and bring an appellate process so that some of the conflicts are actually resolved at the second instance court. Is this we can actually say yes to some atmospheres. After the meetings are finalized, generally there are two other concrete procedures proposed to reduce the workload. One of them is the topic of the next meeting, that Turkey is in need of a general administrative procedural code. Actually, the issue is very clear. If we have so many conflicts and so many case files, this means that we should not be actually focusing on resolving these conflicts at the earliest opportunity, but rather to focus on eliminating them from the beginning and guide the administration to act on a legal basis, resolving conflicts prior to the judicial process and developing certain procedures. I don't even believe these are going to be effective. I keep saying this, and I will continue to eliminate the conflicts to occur from the very beginning and provide the administration is a general administrative procedure code. What is the general administrative procedure? First of all, let's focus on that. Actually, this means that while showing how the legal provisions are going to be applicable on that concrete incident. So, just like when you're doing the prosecution procedural rules and take action accordingly, this is actually what we mean by. So, both the activity of the administration and the activity of the administration that means the administration should also abide. Which acts are actually going to abide by this? First of all, the contracts could also be evaluated within this perfect aspect. For instance, in Germany, when we talk about the General Administrative Code, that are going to be abided by the public administration. You are going to say, yes, we do have provisions pertaining to the administrative contract. These are specific areas which govern the procedure codes, but the special expenditure and some activities that will derive revenue. We have two pieces of legislation, and sometimes we experience difficulties. Plus, with the providing regulations on public-private partnerships, when we're talking about the privileged contracts, what kind of procedure are we are going to follow? We have not put this very clearly. So let me state the following. This legislation is sufficient for these contracts. When we take all of this into consideration, actually a specialized procedural area is even creating further problems. This is something we can see clearly. All these are actually showing required to be enacted at the earliest opportunity. Why do we need a general confidentiality is still the basis in the Turkish public administration. After 1990s, the transparency and open steps that have been taken, but we still see that the public processes are still carried out behind closed doors. And the counterpart of this transaction is only notified when they receive a notification from the public administration. Reasoning when there is a public act. In such cases, most of the time when we notify the counterpart about a certain transaction, we do not actually provide any explanation as to actually have a general administrative process theory. Everybody has their own way of doing this. In our case, this could be used to act accordingly. The authority has been identified in the legislation, and sometimes in the legislation there are some procedural codes. But I'm a graduate of a university, and my faculty and the faculty next door, which is the business administration and economics department, their procedure is different from our procedure. Also, the fact that we have a centralist structure, but we have this centralist structure still valid for the public administration. The fact that there is no participation is again another major problem. For instance, when we're talking about an environmental effect report, there might be certain law people who are going to do this transaction might be called for an oral hearing, but these are very limited. But apart from this, for the individuals, for transactions that are going to affect them in a negative manner, they have no, can see clearly, is that the administration is abusing its discretionary power, and they're not using this on a legal basis. And the fact that the code provides. First of all, let me state the following. The administrative procedure actually, this could be said both for the administrative procedures. And when you look at this, before you do this or before you take this step, it provides the person information as to how they're going to do this, and it is a way of that individual participating in this process. So before they undertake a public administration action, the administration notifies the individual that they are going to provide, is notified to the individual as a reasoned judgment. This is what the administrative procedure governs. It is providing the participation of the individual. This is really important. And why the individual, knowing that there is going to be a transaction about themselves, and when this is going to take place, what are the obligations of the public administration, what are their rights. This is important for the clarity and the legal safeguards code. Foreseeability and legal protection mechanisms are really important, and they are the prerequisite of a procedure law is in line with the democratic principles. We always talk about democratic rule and democratic administration. And of course, this is an aspect, but we always remember the election of certain representatives or certain offices. These are inevitable parts of a democratic ruling system. Yes, that is true. But when we're talking about administration management, this is actually not the same. democracy in administration, whether there is an election or not, was at one point were being chosen. But now there is a new tradition. They are being appointed. This is really important, whether they are appointed or whether they are elected. What is important is when it is concerning my department, my faculty, can I actually participate in this process?
And can I express myself in all of these administrative acts and actions? If I have these opportunities, then we can talk about democracy in management. What is important regarding all the stakeholders, including the students, including the academic personnel, all of their wills are also because, please excuse my words here, but anyone who considers themselves to be considered a man would always be happy. And in the relationship between the administration and the citizen, what comes from the history is the approach of those providing public services and those benefiting from public services. In the past, when we were talking about these concepts, and in our lecture, when we used the words, the ones stood as those that were being dominated and those that were dominating. But right now, when you use the words, those providing public services and those benefiting from public services, we are actually putting the emphasis by valuing the individual and making sure that the individual is engaged when we take action against that individual, getting his consent as well, and actually putting forward the fact that we are required of ensuring human dignity. Having procedural law rules for the administrations in their actions is also very important for you, and I mean the Council of State. Because if through the by the action taken, and this would automatically prevent any disputes, and because disputes would be automatically prevented, then the workload of the administrative judiciary would be reduced. And then because, for example, due to the individual who would like to file a case against an action taken, because they know why that action had been taken, they would be able to more easily defend themselves. And I have mentioned this in a couple of other, putting an effort to fulfill the requirement of providing reasoning in your judgments. And if there's any deficiency in one are completed, then the Constitutional Court, and if it passes through the Constitutional Court, reasoning. In terms of the administration, there is no, actually very important, the fact that there is no reasoning or there is no such obligation to provide reasoning for the public administrations is a very grave situation. We heard from the rector's office indicating that I've been assigned in this or that faculty, but I don't know why I've been assigned there. I don't know whether this is good or bad. I can write in my petition to file a case because I don't know why it's been done. When can I write it down? I can file a case. You may ask for the administration to provide their defense, and that would be the only way for me to see the reasoning. So imagine we have the expedited trial procedure reasonings. This is a very grave situation. I mean, the person who files a case against an action for which he doesn't know the reasoning, situation that eliminates the right to exercise one's have an obligation to provide reasoning for all their actions. Otherwise, as I have just mentioned, then with regards to the right to seek one's rights. Another important requirement for the general administrative procedure is to make sure that the public services are carried out in an effective and efficient manner. And actually, I can guess that you may have some question marks in your mind. And actually, when general administrative procedure laws were being enacted, there have been many pieces of debate. Procedure was Germany, and it was in 1976 that they have enacted their general administrative procedure law. This law was actually discussed for a long time in Germany, and the greatest criticism was that for the administration, they were saying that you are actually rendering public administration not able to operate because you're putting it in a still kind of enacted. And after it was enacted, after it entered into force, they've seen that their fears were actually unnecessary. And they've seen that after this law was enacted and in an impartial manner. Let me just say one more thing. I just talked about Germany. 1976, the Council of Europe in 1977 published a recommendation. I apologize. Let me change my slides here. So it is actually the recommendation numbered 7731, general administrative procedure laws which had been enacted in many other member states. And my guess is that the Council of Europe was actually expecting to act their own laws, and after Germany and France had put in their legal arrangements in place, then this recommendation was actually published. So there are 5 principles which were proposed to the member states so that they would be included in their legislation. This is the right to be heard, the right to have active actions, and to have remedies indicated against the action taken. And actually, the great majority of them have been implemented. So let me also indicate that although we do not have a general to implementation, but for example, with regards to the right to be heard, we still have significant deficiencies. Actually, this actually means the right for participation or engagement. This is not a right that doesn't necessarily to express himself or herself in one way or another. But for example, when we were working in drafting the law, some of the other academicians, these are the rights that have been indicated in this recommendation, but also there's also the the principle of ex officio research, the procedure economy, having parallelship in authority, principles in general administrative procedure law, but they are also very much related to the good governance right, which has been indicated at the time. The charter which had been adopted in Nice was expressed as the constitution of the European Union. Administrative procedure principles are also included, and also in 2001 the European principles have been listed there one by one, and when we look at these principles we see that they are also relevant as good governance or general administrative procedure principles. I don't want to name them. The first general administrative procedure law, it was in 1889. But the main law that had an impact in Europe was the Austrian general administrative procedure law in 1925, which was followed by Czechoslovakia, Poland. Very famous Administrative Procedure Act was adopted, but with certain other additions in 1966 and in 1976 with certain new changes. This was a professor was also inspired in naming his book Government in the Sunshine. This was the law actually. Spain adopted its second administrative procedure law in 1958, and in 1990 adopted the 3 different laws by amending the law, and then in 2004 it was the Czech Republic that adopted the general administrative procedure law last. So I can say which is a country that inspired our administrative system, had also some legal arrangements. So rather than having an overall law on the relationship 83. So actually this indicates a shift in the concepts as well. And I will talk about the situation in Turkey and then conclude my remarks. Actually, we have implemented some of these principles. In a previous meeting, I had already expressed these in Article 40 of our Constitution. I mentioned before, as soon as this constitutional amendment took place, the in their decisions. So from now on, you are writing down in your judgments where the individuals can apply and in what kind of a deadline. But the public administrations are still not fulfilling this obligation in their actions, although this is a constitutional obligation. And we have also implemented the right to receive information in our law relating to this, and we don't have a lot of problems relating to this. And also regarding the right to petition in the law relating to their situation by using a petition, there is a provision which indicates that the result of their application should be informed to the answer within 30 days and to answer together with the reasoning. But unfortunately, we do not see that the public administrations are always answering the petitions in this way. But this is the implied or deemed rejection. Deemed rejection is still considered as a procedure of taking action by the public administration. Is it acceptable? No, actually, the deemed rejection procedure is stipulated in the administrative law, but actually, when someone applies to the public administration and does not get an answer, this actually gives them grounds to file a case. So, according to this provision in this law, they have to answer within latest 30 days. Apart from that, I will quickly continue. In the law on the establishment of the ethics board for public officials, the ethics principles are stipulated, and we see that they're almost. The board is headed by the former president of the Council of State. This council is actually expected to function ethically, effectively, but we cannot say that it has been working very effectively so far. And also the Ombudsman's institution law. So these are actually laws that include principles that will allow the good governance principle regulation regarding the procedures and principles to be followed in the provision of public services. I actually know that currently there are some colleagues who are currently members of the Council of State who worked for the preparation and then the publication of the regulation at the time. This is actually, but let me just say that indeed a general administrative procedure law is essential for Turkey. It is actually high time that we have such a procedure law. But let me also indicate that after some time, and I have participated in almost the majority of all of these, we already have these principles, and let us have some legal arrangements that would make sure that these principles are put into action. And when I look back, I see that a significant part of them are already stipulated in the legislation, and hopefully there will be the will to put these all for your patience. We would like to thank the distinguished professor for his presentation. And now we will move on to welcome. Welcome. Our professor is an academician, a member of faculty in the law faculty of Kadir Has University in 2009. She's completed justice system, and our professor here has carried out several work in foreign countries as well, and taught many courses. And she also has dispute resolution methods in the Turkish administrative justice system. Development of the ADR will help to reduce the workload of the administrative justice by reducing the caseload of the administrative justice system. When we look at the legislation, we actually see that there are various provisions with regards in our law number 2577. There is actually an appeal mechanism which is foreseen against every administrative action taken, and if the public administration deems it appropriate, they can develop solutions by conciliating. And I believe that the public administration will.
Thank you, Mr. Chair, and I would like to greet each and every one of you. It's very honoring that I am here the occasion of the anniversary of the establishment of the Council of State. I had made a similar presentation. I really believe the project is important, and in this context, I would like to say thank you to the Council of Europe, the European Union, and the Ministry of Justice, and we would like to say thank you to the Council of State. That I speak in long sentences and I speak very fast, but I will do my best to speak lower. Today I will be briefly talking about this alternative dispute resolution methods, and after it has actually been used as an acronym for quite some time now. Actually, in relation to increasing efficiency to access justice and also the resolution of conflicts, this has been developed to have resolve the conflict at its source before it is referred to the justice mechanism to resolve the problem at hand. And it is actually to provide a sustainability of the relationship between the parties to the conflict. I am especially thinking that this is crucial for administrative disputes because the dispute between the administration, therefore, that relationship and the parties to that relationship, there should not be any tension between the parties, and thus I do believe ADR methods are very suitable for this. During my presentation, when you look at examples from other resources, we believe that the ADR methods that do not involve any prosecution are almost always in the administrative procedure. The Europe. Actually, here we're talking about procedural economizing from procedure and also accessing a speedy solution. ADR has benefits, and therefore, why do we want to integrate into administrative procedure manner and to establish this relationship between the public administration and the citizen? In our country, it's mostly seen for the private conflicts, and the law, even though it's been somewhat late, the ADR methods have been included in the legislation. So today I will be briefly talking about this legislation per se, but generally there is a block or veto against are stemming from the fact that the public administration and the individual are not on an equal footing, and there is actually beyond a relationship beyond the relationship that people have. Representatives are also not free, and this is a relationship between the various authorities where you need to provide the supremacy of the state of law, and the state needs to use this power to the public benefit. Transparency, participation, accountability are all important to access information. The fact that there is such a block or such an obstacle, this is not baseless. But when we look at this, we see this much more clearly in ADR. This is what I'm going to be talking about is before the litigation process. That does not include any acts of the prosecution. Of course, when we're talking about, we have arbitration there, and with the amendment in Article 99, this has been integrated into our system. But apart from arbitration and so we believe that amongst different legislation, there are various methodology. Law on villages, the law on petroleum, the law on telephones, telegrams, and the use of intellectual property regulation. So amongst all these, we sometimes see things like settlements. The most difficult example is the law on procedural regulation. This is actually done by a commission to identify the damages due to terrorism attacks, to search about this, and also preparing a conciliation, an act of conciliation. It could be the methodology. When we talk about other examples under the law on municipalities and law on provincial administration, 5 billion Turkish lira, they can go to a settlement, and because of deriving from damages. Again, a settlement could be the procedure to be followed. Sorry, I missed to move on with this. There are also institutional methods, especially the Ombudsman institution, which has been established in 2012 and started receiving applications in 2013. Is an independent and impartial complaint mechanism. And of course, this is important in relation to the audit of the Administration Acts, providing recommendations, and this is actually quite a good level of treatment. It's a crucial aspect. And of course, in each public administration, if we are going to adopt an ADR method, it is really crucial for us to transfer this experience, and I do believe that it is an important resource for this. As of 2017, the Ombudsman institution had an article of the regulation which indicated that while the investigation and the research is continuing, the institution can invite parties to methodology of a peaceful settlement could be continued. Of course, which amicable settlement, peaceful settlement we're talking about, how they're going to. Example is actually in the Human Rights and Inequality Board. The conflicts pertaining to the ban on discrimination are actually referred to this institution. Of course, this particular institution also has an authority to issue measures that are making it more or less compulsory. It could be taken into consideration, but this institution is particularly working in the ban on discrimination. I do assess this legislation. I do believe that why aren't you talking about the Decree 659? I'm going to come to that point. For management, different administrations have different ADR methods foreseen in their legislation. But as I have said, this village law choose conflicts that are not administrative conflicts, because there it's not the administration that is the counterpart. Is more like the facilitator, and rather than an administrative conflict, it is actually a conflict between the actors on a certain sector that we can talk about in relation to the ADR methodology. But the Ombudsman institution and the Human Rights and Equality Board, and also the State Audit Board under the Presidential Office, which is actors that are reviewing the acts of the public administration. We can say that all of them have aspects pertaining to ADR. But of damages, as we know, with the Decree 659, the institution of settlement there, this was actually also present in the system before. Damages stemming from certain acts, and for damages stemming from transactions, this is also put forward as an elective methodology. Following identification, when we assess the legislation at hand under Turkish legal system in relation to the resolution of administrative conflicts, so what is this is the system that we want to propose. We need to say from the beginning that as a prerequisite of this is not actually a conflict that the parties can impose in comparative law, which is called regulatory negotiation. I'm not going to use a Turkish terminology here, but this is actually the right to be heard, which is integrated into the administrative procedure. And with this integration, some decisions in the in the Anglo-Saxon law, there is what they call the notice and command, that the parties are informed about a possible regulation. They are heard. So if the ideas are not going to have any effect over the decision or not, the reasoning will still be put forward as to why this is not having an effect on the decision. Therefore, we're talking about an ADR methodology which is integrated into the administration. And for transactions, this is what we can say. But for us, this is something important in our legislation as well. in relation to the damages that are due to or compensation of damages, we see certain examples in institutions. So what do we have in our hand up to this point? Actually, in relation to Article 11 of the Procedural Law for Administrative Judiciary, when the Council of Europe, when there was a conference in one of the recommendation decisions, this was mentioned as a method of ADR, and this is taken into consideration. So this is important in relation to incurred because of administrative acts, and again, this is an ADR methodology that appears before us. In line with all these activities in this project, when we review what we have been doing for the last 4 years, especially the high increase in the administrative trials where the state is a party, and again, that this general administrative procedure is still necessary, although we have been debating this. We were thinking about reducing the workload of the judiciary, but the main function is actually see the conflicts as a result of this decreasing. And we have so many different procedures in legislation, in various pieces of legislation. Maybe one proposal could be for a unified piece of legislation, which ADR methodology could be used for which type of conflict. After having made this is going to require a very comprehensive legislative amendment. But before that, we need to be able to use the current system in a good manner, like the Decree 659, but this within this current framework does not look as if it is being used because of some budgetary problems. The public administration is not providing any compensation for damages incurred, or just like we talked with my professor, there is no also culture. We need to develop certain pilot practices, and I think we really talked a lot about these during the project as well. We also need to identify the following: if we are going to have a new piece of legislation, but we can have a selective mechanism where the participation mechanism is more put to the forefront, and that is going to actually make it possible for us to use the current general administrative procedure code, which will make the life of the citizens easier and make it easier for the public administration easier. There is a debate as to which types of conflicts are suitable for ADR. And actually, there is a distinction between objective and subjective conflicts where require a compensation for damage incurred are more suitable for ADR.
At this point, there could be one more important thing, which is the fact that the settlement application which exists in the current system, actually, ADR is not where two parties come together and try to resolve their dispute. This is not how it functions in our system, because when we talk about settlement, there are both parties of the dispute come together and try to resolve their dispute. But in our system, there's an application to the public administration, and first of all, the public administration has a commission which identifies the damage, and this is actually a little bit different from the settlement that we're talking about under the classical ADR framework. So actually, I consider this settlement a bit more similar to mediation, where and their experience should be benefited from. I think this will be important because the Constitutional Court has a decision in terms of such a dispute resolution, and there they say that in the decree law 663 on the Ministry of Health and in the conciliation procedure that is designed as an internal process, because the independence and impartiality elements are not present, and because the conciliation procedure is not defined in a way that would not lead to any hesitation, and can have a third party to resolve the dispute of the party, and maybe an ADR method where such a third party is authorized could be considered in a future legislative action to be taken. This is what I'd like to say. And just to quickly wrap up, and for now, not to reduce caseload and to further improve administrative procedure, meaning underlining administrative procedure, and party, meaning the public administration and the individual, are result in better relationships. And I think ADR, with the right selected method for the right administrative disputes, for that purpose, we have the legal provisions. In terms of suggestions, there could be many other suggestions. Maybe could be made compulsory before applying to the courts, and if that requirement may push us forward to being more familiar with the culture of conciliation, and also in terms of good administrative public administration, take a breath in terms of negotiatory procedure, and having the methods at hand should be used well and guided towards methods where a third party could help reconciliation, maybe through some changes. The Council of Europe actually, regarding alternatives to cases 2001 to 9, and address there by using different country examples, and I think that could be a very good guide. And the final word would be that the scope of the Decree Law 6, meaning that the local government organizations could be integrated into that scope, so that the settlement procedure could be operated, so that we could have some examples and see the practice. It could maybe lead such a ADR methodologies to administrative cases where we could see more examples. Thank you very much for your patience. Actually, it is until 11:30, but I think we can have a 15-minute break, and then we can start at 11:35. we will start with the second part of the second panel. I'm kindly asking you to be seated, please. Thank you very much. For the second part of the second panel, the chairperson will be Mr. Hasan Güzeler, Deputy President of the Council of State, and also other speakers are kindly invited to take their places. Associate Professor Dr. Ms. Nilay Arat is also seated. Thank you very much, Professor. And now, distinguished chair, I leave you the floor to continue with the panel. Distinguished Deputy President, distinguished guests, dear colleagues, will be Dr. Hasan Gül. Hasan Gül is a member of the 13th Chamber in our Council of State, and in the past he worked as a tax inspector, director general in various other public institutions. Provide a presentation on an assessment of the alternative dispute resolution methods in the Turkish administrative judiciary system in terms of comparative law. Greet you all with my regards. First of all, I'd like to give you some information about the scope and limits of my presentation. After all, one of the main components of this project, one of the outputs of this project, is to reduce the caseload of the administrative justice system and to create some alternative dispute resolution methods. And certain studies have been carried from other resources. I have tried to address exist in the Turkish system as far as I could reach. I'd like to provide you some number-based information. As was mentioned in previous, within the framework of reducing the caseload of the administrative justice system, ADR method, wondered whether this question mark that I had in my mind is also a question mark for others as well. So when reading that, I actually thought that reducing the workload should be an auxiliary conclusion, and there should be other primary objectives other than reducing the workload. And actually, in other sessions, other expressions which seem to have captured the essence of the situation in a much better way. And I'd like to provide some quotes. What ADR methods are actually expressed, according to my opinion, in a very well-defined manner in a judgment of the Constitutional Court. And this is a judgment of the Constitutional Court on the basis of an annulment application. But of course, we should also not forget that this was actually in the framework of that application. And the Constitutional Court here emphasized that these methods, in terms of their assets, rather than having a satisfactory solution for both parties, and in parentheses or in quotation marks, it indicates that it could be used in disputes that are not relevant for public order. So as members of the judiciary, our aim is in disputes relating private law and not very much in administrative law. And it has most recently started being subject to administrative justice. During my reading, and actually in 2016 in Istanbul, units in Istanbul, there was the same actually topic which was covered, and I participated together with my colleagues. And at the time, the Secretary General of the Council of State had this expression. These alternative methods had always existed. They existed even before the institutionalization of justice. And now we are rediscovering them, and these processes are serving to social peace, and they are more silent, calmer, and more humanitarian. And I believe that this should be a bit colder to me. I mean, this feels as a warmer objective for me. This was also emphasized in previous presentations as well. But then we consider this objective to be more lofty. And another judge, which established the judicial mediation system in Quebec, Court of Questionnaire was prepared, and including Turkey, 37 countries answered the questionnaire, and then in their answers, the of ADR methods are a very marked example of the society taking responsibility in the face of and actually in continuation it is in we can see that they are trying to establish in a different way, but there are many others who still have question marks or this topic in an article, and I tried to translate it into Turkish. And this is actually 15. In an article, he states that alternative dispute resolution methods in administrative law is that an essential step increasing the satisfaction of citizen, or is the way to translate it. So it means that still people have some hesitations. So when that we should not expect much from the ADR methods, and by correcting the functioning of the judiciary and by making it more efficient, many other problems could be already resolved. In terms of the general views, after all, as I mentioned before, within this project, there have been certain study visits to some other different countries. But actually, in 2016, during the Istanbul conclusions from 2016, whether the examples given in these answers are still valid is the idea, whether they have been further improved or whether they have or not. But we should know this limitation. These are the information that I have referred to the seen that the ADR methods that are applied in these countries are not that much different. They are almost the same, but there are some interesting examples which tax the most important things is to set precedent, to create. It is important so that they can see what is ahead of them. And in Sweden, a mechanism has been created, and there are other examples that could have taken half a day to talk about. Here, the Preliminary Tax Decisions Council works as a quasi. Is this applied if a new tax is introduced, or if there's a situation that requires complete the administration by the administration or the taxpayer, and this can be appealed to the High Administrative Court. So the process of following this may appeal to the decisions made by it is in the favor of the public administration. Do we have this? Yes, we actually have, as per Article 4, the tax administration. And then interesting for me, and I wanted to provide you information about that. But let me also indicate that my study is a little bit too comprehensive. I'm not interested. They can also benefit from my presentation after obtaining methods during the trial. For example, Austria, in the answers to the Congress, we see that have been established to provide a resolution before applying to the court, and also the judges in the administrative courts can also carry out some agreement procedures. This is interesting, and this can be found in some other dispute resolution methods to reach a resolution. It was also mentioned before. For example, service providers and public service recipients, certain methodologies can be created, but then those mechanisms can also be carried out by the court as well. At least this is what we can observe in the answer as well. So in which areas the regulatory and supervisory authorities are functioning are indicated here, which also include public procurement as well. For example, in the troll state law, it is indicated that until the contract is signed, the administrative court can, of course, there are certain different methodologies that have been introduced as per the state system. Also in the local government chamber, and also in the Vienna province unit is formed in another provincial administration. So they are faced with a situation that needs to be resolved, then the citizens have certain mechanisms that have been created to allow them to apply. This could be at the governor's office or even at the courts. We see that these mechanisms are available.
Mandatory application methods, and there are actually obligatory application methods like 140 areas, but maybe here we need to focus. Such administrative applications are generally not done to the same administration, but to an organ which is independent from the administration, and this is generally like in Article 1 of the there are not many results obtained from the application to the administration or the supreme organ, but it will be much more better if the application. In 2016, there has been a system that was implemented that was supposed to end at 2021. I don't know whether they use the methodology of applying to an institutional arbitrator transaction, whichever area of service that they are benefiting from. There are such mediators appointed, and they are specialized in those actions. They are the mediators that know that public administration output. We have the impression that it was more successful. Here we have the report of France. It was a study visit to France, and I would like to congratulate our colleague who has written this report. You can also have access to it over the internet. This is really a good report. And this is we see that the most successful example is in the employment agency, and out of the requests of 2,746, in 2,703 of them, there was reached to it was finalized. In 2,579, there was a solution to the problem, which is 98%. The same mechanism has worked in other units as well, and here you can get more information about this. Again, if we focus on other examples, in Australia, again, there was a questionnaire that was done in 2000. I believe that it's an institution that is similar to the Ombudsman Agency, and everybody can make an application. There are more than 400 such reviews. Again, here they mentioned that the most frequently resolved. It also can use ADR methods. There is a meeting, an initial meeting, and the board authorities. When we look at this, they have actually a structure which is similar to the Ombudsman institution. Here, one thing maybe we need to underline is the following. When the consideration new information in order to come up with a decision on that matter. Here, what we can understand from this is, in the end, this is beyond the judicial review, and there is actually a new perspective in order for the parties to reach a settlement. There's also another practice in Belgium. It was translated as an administrative circle. I don't know how it was referred in the original. It is a mechanism that has been brought to the law and Conseil d'Etat, and here an authority to make a notification to the public administration whose transaction or whose act is the subject of the complaint. If the particular act is remedied and corrected, this is ending is a special role for actually eliminating that transaction for total. we are also aware of this during the prosecution. Sometimes quashing or annulling that transaction might not be the most suitable solution. And I believe that the aim of this is in certain selected situations. They are notifying the administration, okay, I'm going to annulling this act, but resolving this matter would require such an act from your side. So here, actually, because it is overshadowing the independence and impartiality of the judge, since the view of the Council of State is expressed before the whole process comes to an end. I don't know whether seniority, compensation, etc. And it is indicated that these are areas for some cases where the judge is also accompanying the mediator during the mediation process. Here, we should have thought about a question mark. In this method of mediation was mentioned to be in use, but in conflicts, it does not actually recall the same thing in each and every country, something which is the topic of an atmosphere might be considered vice versa in our country. And the statistical data which indicates that mediation is used quite 2016 during the Congress. This was something that we experienced firsthand, and with the French part, different things. And I would like to explain this through an example, because in the Istanbul Congress there were certain working groups, and one was on public tender contracts. There was tax, there was public services, and we were given the following study, and these were the case studies that we would be talking ADR about. So we went, and the contract has been signed, and during the implementation phase of the contract, the process was delayed, and there were additional costs. And the question is, can the parties resort to mediators, and can the mediator be an administrative legislation of France? The public tenders are an administrative task. In our case, this is not the case. They are what we were discussing was actually not an administrative transaction. The fact that this is the topic of mediation in France was not something that's suitable for our case study that we had prepared was, of course, the phase prior to the signing of the contract and the conflicts of this pre-contract stage. In the end, we did discuss, but we came across to the under the scope of ADR or not. When we answered this question, whatever is called administrative action, we need previous presentations where mediation or settlement is implemented. Most of these are actually not administrative acts in our legislation. Therefore, when we look at the case studies, this should be the scope that we need to pay attention to. Okay, we can pass these. In Germany and the state of Bavaria. Here, the court does a settlement, and the case is referred to, and I just wanted to mention this because when we look at some of the examples, we want to concentrate on a judge, and these are conflicts between neighbors, and the cases where the parties to the case have long personal relations. There is a Germany report prepared by another study visit, again in a visit to an administrative court for a settlement, and for quite some time now, at least some focus on administrative applications, when they are made to that authority, because I have the following reservation. We don't know how many applications were made to the application under Law 2577, Article 11, and we don't know what is the success rate. Which data we are saying this about? Of course, we cannot say that this is an opinion in vain, but while we are saying this, we cannot also say that we have an important and considerable amount of data. A methodology which is in the public tender law, there is a preliminary complaint application, and in the end, the board takes a binding decision, and the majority of the count figures here in 2006 and 2011, there's a period in which I was the president for this. Also comes, of course, to very important years. In this particular, in 2008, for instance, not. Of course, this is again open to administrative review. To what extent? What is the percentage amongst these decisions that is referred to litigation? In the initial years, we can see that only a limited number were referred to the court. And when you look at column number 4, you see that in it were referred to the judiciary. And the others don't have time to debate it that much. In the end, we can say that tender board are now being taken to court. So we believe that the function is not rendered that effectively. I would just like to give one example, and then maybe a few more slides, and my presentation will be over. And of course, you have banned acts and behavior. They are banned from entering into public tenders for 1 or 2 years. Whether there is an investigation prior to this administrative ban, whether there will be a defense provided or not. So what happens? This ban, but the law also says that participating in a tender when you're aware of this ban that is published in the official gazette. So while they're under a ban, this, in my opinion, is like such a simple topic. Why can we not resolve this? This is a question mark that I think about, because the person, it's not easy for him to pass through this filter. He will be caught. So when you're not expecting that individual to bid in a become banned once again. So I believe that the administrative procedure is really crucial, and this is a good example about this.
Let me just say one more thing. 2015, many of my colleagues were also present. There was a meeting in Antalya. Mr. Gül, or 2 minutes, Mr. Chair. Here in this meeting, very good work had been undertaken. Reports have been prepared to them as well. For example, in the competition law, according to the competition law, the reconciliation procedure is also introduced, and also in the customs law. I'm not going to go into these. They're all that the disputes would be resolved. The commitment part, if there's a competition procedure. And I would just like to indicate some numbers to see to what the years. In 2021, it was first introduced, and in 2021, meaning that there was no violation in terms of competition. In 25, there's been a penalty given, and 5 have been concluded with a commitment. And the 6-month practice in 2022, we have the numbers from January to June, is also guiding us. We see that we can see this from these numbers. There are some other examples, but these are rather better known, so I don't want to dwell on them right now. And those who would like to see the study in full, of course, if they request so, I can provide them with this study. Thank you very much for your attention. My regards to you all. For now, we will now move on to the discussion part of the panel. So let us ask the left side. Any questions from this side? I cannot see any questions. Okay, from the middle section, Any question? Hand side of the room. Yes, could you please pass over the microphone? Thank you very much. Introduce yourself from the Director General on Legal Affairs. I'm also a judge in administrative justice. My name is Metin. So, with regards to the requirement of using ADR methods in administrative justice, we agree and we understand this from the professor's presentation. Taking this one step further, and I'm speaking for the existing ADR methods in the administrative justice system in the Decree Law 659, in which types of cases, regardless of how we name this, mediation, conciliation, settlement, under which types of cases, or in terms of which types of cases we can start. If she has any concrete suggestions, I would be very happy to receive them. And also, in previous presentations, she mentioned in some other presentations, Ms. Delay, used as an official legal mediator, including our distinguished member of the Arat. Thank you very much, Mr. Metin. Actually, for quite some time, we've been working together under this project, and towards this weekend, we will also be discussing ADR as well. It was already included in my presentation. I did not talk this. I mean, which disputes could fall under the scope? We actually thought quite a lot on this issue. So actually, we have said that as a general framework, that they would be actually the disputes that require a compensation. For example, there's cases which relate to adequate pay, and also it is with regards to rezoning issues. This was also covered under an ECHR judgment in case of cancellation of license. So rather than those disputes before the license is cancelled, be some disputes that may arise in zoning issues, and also with regards to social security and civil servants law, especially the per diem issue could be considered within this framework, and also for certain acts and confiscation cases without expropriation, they are actually following a process, but we see that the public administration is actually exercising an authority without expropriation. So maybe they could also be considered under administrative issues, and also requests for compensation for public immovables. So there are also some other experts where there are examples about an administrative action, but for example, students grading or identification of grading, certain discipline-related disputes. And of course, I'm approaching this very cautiously because disputes that may arise with regards to the evaluation. Also consider this in terms of actions that fall under a court expert, because whatever the court expert tells them, the judicial emergence of ADR is that the disputes relating to disputes are resolved in a much better way if they require specialization than they are actually resolved in a better way through specialists. In terms of the second question, the court that could be suggested, yes, the experience of the Ombudsman's institution can be benefited at a very high rate, I believe. And actually, in the legislation, in terms of the settlement under Decree Law 659, I think that the same thing could be applied. And in this way, Article 12 serious manner, and then the disputes at this level without keeping the court busy through trial process. I'm also one of those who think that this is possible. Thank you very much for your question. It is appropriate for ADR. Everyone actually quite agrees. What are these? The issues where the parties can negotiate. It could be a certain room for negotiation. And then when we talk about the discretion of the parties, then on one hand are relating to the good functioning of the public administration, and on the other hand, I tried to mention this in my presentation, still, if the administration action has been taken, at least the parties I mean, there could not be sufficient reasoning, could be brought together in a meeting, which I may call a meeting to understand each other, or friendly amicable settlement meeting, or amicable settlement meeting. Because what happens here is that when you look at the situation on paper, the situation feels each other, and you can actually use that potential. And when we look at the situation from the perspective of our citizens and our culture, after all, when you use an appropriate language, no reasoning, or if it is not satisfactory reasoning, of course, for the citizen, this means that there would be no other non-judicial. If yes, let us pass the microphone over to. There's one person with a question there. Bahtiyar, the right for good governance or good governance method. And actually, I consider this to be a topic that should be addressed within the framework of fundamental rights and freedoms. And I believe that there stand. And I'd like to hear more from you on what the judiciary should do. Let me introduce myself. My name is Oya Işık. I'm a member of the at sufficient level. So through the case law of the judiciary, through their judgments, to make sure that they are responsibility of the judiciary, I'd like to receive your comments. Thank you very much. Let me just express right at the beginning that especially for the Turkish administrative law, in terms of its feature, we always say that it is actually a procedure-based branch of law. And actually, Mr. Alperen prepared, we have the common law, and when the judiciary is rendering its judgments, certain issues are taken into account, but ours is a little bit different. So actually, many of the rules of the Turkish administrative law are put forward through the case law of the Council of State. For example, in full action case, certain principles that you have developed, for example, equality in terms of public burden or other fault developed by the Council of State. So in terms of administrative law and in terms of establishment of the right to good governance, it is absolutely certain that the Council of State has a very important role to play. And how will the Council of State do this? Problem in our legislation, because there are certain provisions in our legislation that force the public administrations to follow the provisions in the law. But unfortunately, the public administration carrying out the judgments of the judicial authorities. This is maybe a topic for a separate discussion, but the fact that the judgments are not being implemented and there's a resistance against implementing the judgments of the courts, unfortunate. There's one thing that I always mention in the lectures. This is for the annulment cases, the cancellation cases. We are saying that they are public and they're absolute. So do not have such a habit. When an individual files a case and when that judgment is enforced, it is only enforced for that person, other particular case, and that actually reduces the value of that judgment. So actually, yes, then this gives a lot of workload to the judiciary. Let me give you a simple example. I mentioned this in my presentation, indicating remedies, the principle of indicating possible remedies. UK administration is not doing this. So why do you not consider this as an unlawful act by the public administration when you receive applications? Because this was also discussed in the Council for the Unification of the Case Law, indicating remedies and the deadlines for these remedies. Why do you not consider this as a formal condition? When asked, always it is mentioned that we need a detailed legislation about this issue. That is also right. For example, during yesterday's discussion, distinguished Rosen Nogulu indicated that with regards to deemed rejection, she mentioned that in France it is now applied as deemed acceptance, but there is also a list which is indicating those that are accepted as deemed rejection. This is not simple. Actually, to deemed acceptance. This would actually cause many other problems. They also need to be separately regulated. But with regards to this separate regulation, the judgments of the judiciary is, I believe, authorized and has the power to its duties to the full extent. There was one more question towards the back. My name is Osman Danacı, Rapporteur Judge of the 12th Chamber of the Council of State. Mediation, settlement, and various other ADR methods have been mentioned. But of course, these procedures are very good procedures, in a short period of time. And as a person who used to work at the public administration before, when these methods are being applied, of course, the citizen would like to apply this. But when we look at it from the perspective of the public administration, I think that the public administration have difficulties in, well, they are not the target party, or they are not our counterparty. We used to always say that we are actually not a party. We are actually doing whatever is required by law, and that is how we will carry out the administration closer to ADR. What could be done? This is, of course, a general question. I don't know which speaker could answer, but how can we further encourage the public administration? I remember there were actually approached that table. Of course, the individual can approach that table because they have a benefit and they want to gain a benefit and they have an interest. But for the employees of the public administration to be able to have the views of the speakers, it actually has a very brief answer. The culture of settlement actually applies for both individuals and the public administrations. I mean, the fact that it doesn't exist. I mean, the public administration, they wait for the decision of the judiciary to act, even in the simplest of cases. So when that is the case, establishing that culture is a big issue. And that culture, as is the way it is applied right now, has been passed on from generation to generation. So it doesn't seem very likely that it will change soon. But maybe through pilot practices, training, maybe we could help them approach that level. Otherwise, I cannot think of any other options. But in-service training is very important. It is important in every field for developing technologies for various reasons. But especially for these kind of procedures, this should be thought of as an option. First of all, maybe, as I mentioned, maybe it could be possible through pilot practices. The issue here is that, first of all, the individual should apply so that that dispute can be resolved even through settlement. And there may be creating more awareness among citizens, individuals, and to, first of all, I'm not going to say reveal the dispute, because it is the individual that should take a step to try to resolve the dispute. First of all, the individuals should be, we see that these kind of initiatives are being very successful. Maybe starting with these, then proceed with in-service training for the public administrations.
I am looking at this from this perspective. This was something that was brought on the agenda of the working groups, and it was debated quite some time. And we have certain reports for the functions. This brought to various actors in the field. This was debated at that point, but we also need to say not mediation, but a settlement type of mechanisms. Those civil servants who are going to undersign this, discretionary power of the authority should not be the subject of an investigation. It was mentioned as the following, and it is actually a system that works on the audit reports of the inspectors. In the end, we were actually writing a report, and we were reaching a settlement on that report. After proposed a certain tax and a penalty, and there were decisions, and this was eliminated by almost all, because they had written a report in violation of the case law. But of course, they make me accountable. But debate, they discussed why they have eliminated this or not. So those people who are actually undersigning such settlements amongst the public officials, it was always reminding them power given to that settlement commission. This should not be questioned, and this discretionary power should be used in line with the approach that looks at two sides of the coin. Maybe the public officials in our country do not have this, or they earn this discretionary power, but they cannot explain this. We need to explain this with a various approach. Maybe these are in-depth issues, and this means that at least for public officials who are going to undersign such acts, apart from those actions that require questions. May I add something, Mr. Chair? For instance, I do believe that I have proposals for this settlement to be reactivated, but this has now been contradicting it, especially in relation to monetary conflicts. The public officials rejecting the application. It's not coming from their own pocket. In the end, they are rejecting this, but they are again rejecting this on basing on a legislation. Maybe at that point, provisions that they can reach a settlement up to a certain threshold. I had some proposals under the decree 659. Maybe we can think about these, and in the end, if there is no settlement and if this is taken to court, we should actually make it possible to go to a settlement. Therefore, I do believe that liability principles, both for the public officials who are going to make that decision about a certain threshold, reasons why the administration does not reach a settlement. I was proposing that the obligations need to be much more clear, but after what Hassan Bey has said, I will rethink them. There is no conflict actually between your opinion and this. Here we're talking about public officials who are asking for a safeguard. If we can have such safeguards. Thank you very much. Any other questions? Yes, somebody is raising a hand. Greet each and every one of you. I'm the chair of the First Administrative Court of Gaziantep. I'm actually not going to ask a question, but it will be a contribution. In our legislation, we talked about, and I think when you look at our legislation in general, actually all of these are foreseen. I was also the chair of the Mardin Administrative Court, and there the settlement was really an important instrument. Actually, 80% of the cases were compensation cases stemming from this particular legislation, and there's actually a system there. The law 5233 that was enacted in 2005 foresees this mechanism. And there was an extension for this deadline as well. Council of State indicated this is in the context of right to property. When we're talking about evacuation of villages, they can make an application to the administration to make this payment. When we went there and met the relevant parties, they're saying that the legislation gives them this authority until May 2008. Therefore, the Council of State do. Therefore, the administration needs to be encouraged to implement this. In my opinion, this is something that we could be resolving only with an institutional structure. And how can we do this? For instance, in compensation cases, if we had this structure including all of this settlement mechanism, just like a court, is similar with the judicial power. If there is a safeguard provided, you can say that, okay, you are the conciliate. Sorry, you actually triggered me to talk more after these comments. the administration could follow the following methodology, and maybe we're expecting a lot from them, but up to this point, although the law has expired in terms of implementation, the case law on this is creating a sufficient infrastructure. Of course, the issue is a different dimension, but apart from that, there are a lot of laws on the railway network, which is really. There are a lot of related legislation, and be skilled in doing this, we will have resolved the matter. Thank you very much. Anybody else who has a question? I think there are none. We have now come to the end of the second session. We would like to thank the distinguished speakers. We have a ceremony to present our tokens of appreciation. We would like to thank the distinguished speakers, and as a symbol of this thanks, we have these tokens of appreciation. Now I would like to invite Mr. Mahmoud Vural, the acting president of Council of State, to deliver Associate Professor Nilay Arat from Kadir Has University, please. Professor Dr. Bahtiyar Akilmaz from Ankara University Faculty of Law will also receive his token of appreciation from Mr. Vural. Mr. Vural, we will host you on the rostrum for a few more minutes because we have the token of appreciation to the acting president of the Council of State, Mr. Hasan Güzeler. Member of Council of State, Dr. Hasan Gök, is also going to receive his token of appreciation. In memory of this session and of the day,
Teşekkürlerimizi
thank you very much. Thank you for your contribution. Our third session is going to be on specialization and will be at 2 o'clock. So please, we would like to read. Meeting once again. With a few minutes, the third session is about to begin.
Saygıdeğer katılımcılar.
Distinguished participants, we are going to join project on improving the effectiveness of the administrative judiciary and strengthening of the organization. And I would like to invite Mr. Öztatar to moderate. Our presenter will be Mr. Bülent Küfüdür, who is the president of the Ankara Regional Administrative Court. And the next speaker, Association of Administrative Law Chambers in England and Wales. Following her, we will be listening to the presentation on special. And the last speaker will be Mr. Abdurrahman Gençbay, special break in between the speakers, and we will have a discussion at the end of the session where you will be able to ask questions. Our colleagues will assist you in the microphone, and I would like to leave the floor to Mr. Öztatar. Distinguished Chair, this room. And since yesterday we have been really listening to important and valuable presentations, and I would like to thank each and every one of you who has participated. This is the last 2-3 months project under administrative judiciary, and we were very excited because before that there was no other providing very valuable outcomes, and we had good cooperation with the presidency of the Council of State, and I would like to thank the President and the Secretary General for their cooperation. During this period, I do believe that we have achieved the targets that we had set at the beginning. As you know, the aim of the actually a very difficult area. There are difficulties all around the world, but it's also difficult in our country. But I can say the following: when we listen to examples from very important, and the name of the law was Justice in the 21st Century, or that there was going to be a draft law that was prepared after that. I do believe it should have been enacted by now. And in relation to compulsory, it was the beginning when we went there, and now it has become and much more extensive in scope. And also in Turkey, we have a practice. We can start mediation practice in labor dispute. And we made a preference. We actually made it compulsory for the conflicts to which the administration is a party to. And currently, we have seen in scores and 10,000s of conflicts where there is a settlement. And there are, of course, others where there is no settlement. And where we asked abuse their authority, there could not be any investigation against the members of this commission, and there could be no penalties. But we saw that seen that once again the Commission's developments have been taken back. So in relation to ADR in administrative judiciary, I believe the most important problem is themselves, and even if we had the legislative framework, this was not seen sufficient. Actually, the auditors of Court of Accounts would not be able to review this, but taken to Court of Council of State, there is actually now a file which is in one of the chambers, and it has been referred to appeal, but there is no judgment yet. And when we come to the topic of this session, specialization in administrative judiciary, this is also on our agenda as the Ministry of Justice. It seems as if specialization maybe should start at the very beginning, and maybe there has to be an internship in those areas, and the appointment should be happening later on. I think it would be really beneficial. Very easily resolve the case in front of them, and such a judge with their judgments can actually reach to a satisfactory solution. What we call arbitration is actually this. We talk about arbitration having extensive scope in actually commercial law. The reason is what we call the arbitrator is actually a judge who has become expert in the commercial law, and because they have specialized in that area, they're both prosecution, but judges in this area, this is going to be beneficial. Another important issue is the legal expert issue. These are actually judges, the effect of that report, and then we have difficulty in attaining justice. Therefore, I believe specialization is a very important issue, and I'm really glad to be talking about this. Having made this, Bülent Küfüdür, who's going to be talking about specialization in the administrative judiciary. Thank you very much, distinguished participants and distinguished colleagues. I would like to greet each and every one of you, and I do wish the symposium to I will try to focus on the specialization in administrative judiciary about our opinions in our administrative court. We have actually established 3 different commissions. Some are now members of the Council of State, some are presidents of various chambers. Afterwards, when the judicial reform strategy document was being prepared, this was once again brought to since it requires specialization. After the Court of Appeals was established, this is something that we started. Ali Çopur, Hadi Şemşer, Gülfiliz Aslantaş, and all our colleagues who actively worked in these commissions. This is, and as we all know, this has become an aspect that we focus even more in the Council of State and in the regional administrative courts with the regional admin courts. But the regional admin courts have more division of labor. Why? As you know, in the recent prosecutors in relation to the number of chambers, etc. Therefore, in the regional increase of the task, there is either additional duties given to the chamber close to each other that are selected, but different things might be seen in different departments, and therefore certain things where there is no legislative unity or harmony, it means specialization in the modules or certain units, and it's mostly a numerical distribution. This task, specialized judges or teams that need to review that. Therefore, specialization is important, is specialization, and today we shall be talking about specialization. The first instance courts, it was about its advantages and disadvantages. When we look at the meeting of the specialization commissions, so we have always talked about this advantage, disadvantage, what kind of pluses it will bring, etc. Having accumulated this experience by way of case law will make much more speedy and correct judgments, and this will actually decrease the burden. Important because in Ankara, Istanbul, Izmir, where we have more than one administrative court, of course, on everybody has a different opinion or their own interpretation about a specific topic, and of course, it's very difficult to come up with different judgments in the almost same case. And of course, this is a real benefit when we are seeing different judgments. This is overcoming the complications that might be created. Another aspect is actually training in the judges, different topics, whether they are responsible for it or not. And it's a cumulative training that is delivered. Maybe they will not even have such a conflict before them to the specialized judges, and this will actually maximize the benefit of the in-service training, and time will not be lost in vain. Of course, not be working, for instance, if a judge is experienced in energy law or settlement law, they will feel themselves to be more productive. They will have more experience there. So attaining for them to work in that area is going to be very beneficial. Environmental effect report, tender issues, these are all concerning more than one individual. And of course, in distribution, when the case is litigated by different individuals, it can be referred to different chambers. And if each of them have a different legal expert, we can analysis. Or if there is another court that is doing the legal expert analysis, then it takes a lot of time because the other courts have to wait for that. So by this linking cases decision, we will actually have, not in theory, but in practice, provide a specialization and collect it under the jurisdiction of court so that there is no time loss or effort loss. Sometimes the courts are not even aware of each other. We had this in, for instance, customs in on the same topic about the cancellation of a question in an exam. There were two different outcomes. At this point is because there are such difficulties and that there is no sufficient data. So how are we going to actually train the specialized judges? What is going to be their duration of activity, their promotion, or their audit? Of course, many of them require legal amendments and also principal decisions of the Council of Judges and Prosecutors. Before we activated the specialized courts, the planning of such courts have to be done, but the UYAP system should 259 codes in administrative courts and 113, I think it's 300 cases, and there it's 11,000. So the other category is even larger than, and so we cannot have this as a specialization area because it includes anything. Therefore, the coding for it and its case file code activity of this project has been very crucial. And because of long years of service in certain specialized court, they're going to be appointed, establishing the distribution mechanism. This could be very easily established, and according to the regulation, the regional admin coordinator. And of course, such decisions that have not been provided by authorized specialized courts, what is going to be the procedure when we appeal to this decision? So if it's a judgment that needs to be rendered by a specialized court, which institution is going to provide this as a reversing mechanism? And this could be requiring a legislative amendment. But we do believe that the most important difficulty we have seen is a certain type of conflicts, even before they are referred to the judiciary. The preliminary info on the court as well as the judge. This is natural in our country when people want to identify the court and the judge. For instance, we have 28 administrative courts, so 5 are specially authorized courts with the state of emergency. We do not know unless who is going to review that case, and it is going to create problems beforehand. I really need to identify this also has a cultural infrastructure. In such cases, but of course we now started seeing ban from entering a tender process. Sometimes the tender case decrease and decrease, closing the courts or decreasing the number of members of that court might be the problems that we face.
The reasons that would require specialization in administrative justice. In actually ordinary justice, there was a partial specialization that was on the base, and also in trade, others, there was specialization. But although the regional administrative courts have been established, except for Council of State, we did not have distribution in terms of the jurisdiction subject matters. As I mentioned before, there are 372 different types of cases. These are being dealt. Others like boards such as the Competition Board, RITUG, or the Energy Regulatory Supervisory Authority, their cases have changed actually. Administrative courts who used to deal with our competition cases are relating to issues that require a high level of expertise and specialization, and finding well-trained judges and specialized judges who would be able to try these cases. That is the desire, both at the Citizens Registry and also the courts. I mean, we no longer have these classical administrative cases. We now have specialization is necessary. So in general, the number of cases have increased, and also we have a variation in the topics that are covered, and it is also foreseen that the Courts of Appeal would be established and they would work as specialized councils. This is very important. Current number of judges should be at a sufficient number that would allow for specialization. When we established that, is not something that is very much desired, and we could not have transitioned to this system because we did not have sufficient number of judges, and the codes of the cases in administrative justice is the law on the protection of the foreigners. There are several courts that are authorized in Istanbul, and also we have another one that is authorized to cover state of emergency cases. And because of the high number of cases, they are now closed off to general distribution of cases. Otherwise, they are still receiving cases from the general distribution of cases. So this is not a full kind of specialist, because if this is not, this would not be serving to the purpose. And as a specialization on the basis of considering the relations between the subject topics of the cases and their relationships, this is actually the desired method and the one that we also suggest and would like to have. Again, specialization according to the procedural differences. Okay, let us specialize is also not very appropriate if it is done according to procedure. Specialization by considering geographical location or jurisdiction, I mean, it was not very much considered in certain tax cases. There was an example, the High Military Administrative Court. It is mentioned in a provision that the cases relating to military service would not be tried by the administrative court where the individual is, but in the administrative defense. So I will just go over principles for specialization. We should not have only a single court that is a specialized court on this issue. There should be several, and the numbers should be identified by considering before starting with the specialized court. And except for certain cases, they should have worked for at least 5 years, if possible, at the Council of State or at certain regional. In the specialized courts, there should also be courts of general. And by the way, in total we have received 111,000 cases, 81,000 of them have been completed, and of the remaining 31,000, 8,000 of them are relating to state of emergency. When we're talking, we are saying that the Ankara is the main actor when we're talking about specialization in administrative justice. Ankara should be the first that should come to mind. Maybe we can also list Istanbul and Izmir. We are thinking of specialization in 4 main groups. The first one is tender. The tenders that fall under 4734, 4735, 2886, and also the decisions, and we cannot exactly learn about the exact number, and also disputes that arise from the build, operate, transfer model. And the second, in terms of their workload, and also in terms of complete procedures, application procedures, review procedures, in terms of the variety of the work, and because they have different fields of specialization internally, there was a need to separate the Public Procurement Authority from other authorities. There's already a certain level of workload, potential workload, and if we were to combine it with the Public Procurement Authority, it would have been creating a different high court, and that is why Radio Television Supervisory Authority, Banking Regulatory, let's write it down, and also the Competition Authority, Also, the issues relating to tobacco and alcohol market regulatory supervisory authority. We also talk about third group. These are examination operations because they are usually, in terms of timing, are subject to one court. For example, there's a cancellation of one question or a cancellation creating specialization, and these examination actions indicate a very high number of cases. They include examinations that are held in institutions or for PhD into two subgroups. One is relating to plans, parcellation, zoning practices, relevant legislation, and there are also some other connected issues like this demolition or zoning, these actions. One of the most important criterion in specialization is that connected cases should be tried in the same court or similar court, so that is why you cannot separate them. In the statistics, because we did not have sound data, 1,659 cases have been missed. The number of cases that have been taken to appeal or other levels, we can estimate that there are approximately 2,500 cases that are relating to procurement. So 2 courts would be sufficient for 2,500 cases, and actually on average, they would be covering 1,200 or 1,300 cases. So we think that 2 courts, 2 specialized courts in the area of tenders would be sufficient. And also for the supervisory regulatory authorities, and also in competition authority, it turns out that there are only 3 cases recorded, but that should not be the case. So here, approximately 2,000 city market are actually topics with a very high workload, and currently, because of falsified documents being used in fuel oil stations, there are at least 6,000 cases. So the importance of case codes because these kind of actions have a potential of further increase, especially EPDK, competition authority. It is not possible to keep their workload at a certain level at certain periods when they increase their audit activities, or if there are more applications, because there's a potential for further increase, and because there are several regulatory supervisory authorities, we have foreseen that there should be 3 specialized courts here. So the personnel affairs of these authorities are not relating to this. Only the internal functioning, their personnel affairs or their pecuniary rights are not exact, but the estimate is that there are approximately 2,000 cases. There are sometimes increases or decreases in the zoning cases, but especially if there's a demolition decision or administrative fine, there is a potential for further increase in the number of cases. And also from a numerical perspective, taken to ordinary zoning cases, demolition, expedited expropriation, 6306. I mean, when one case is received, it may include hundreds or tens of different cases that are connected to that. So to be cautious, we have foreseen have special authority, and they have only 8,000 cases left dealing with the state of emergency cases, and hopefully by July they will be finished. And currently there are approximately 900 period that would allow them for transition to specialization. So 17 courts will continue as general courts. So the 30 to 35% of all the cases may be put under specialization. I mean, the numbers may change, but at least 30% would be placed under specialized courts, and the remaining 70 or 75% would be tried by the remaining 70 to specialized courts. Then the time and effort to be spent by the general courts to be spent on general cases will be higher, so they will become more specialized as well. And because the topics that are, there's one more view, and I'd like to convey that could there be a different model in specialization? For example, actions that are relating to the legislation on social security institution, and actually some of them are dealt with the rest of the military personnel. In terms of jurisdiction, they have been changed, but there are also some conflicts of jurisdiction among the court. This is relating to personal affairs or public housing. I mean, it's no different from issues relating to Minister of Interior or us, maybe in terms of their ranks or allocation of their ranks, and old. And because in judgments that are quashing the various judgments are very high in number, and because they may be added under this other group, and currently there are 7,000 pending cases, and the total number of cases exceed 12 or 13,000. The early retirement regime to be implemented, we think that there will be a very high number of cases to be taken to the administrative courts. So, do we need specialization in courts that are outside Ankara? Istanbul and Izmir are the two regional administrative courts that may be closest to specialization because of the number and the variety of work. And we've also reviewed this case and consulted with our colleagues in Istanbul and Izmir, and especially in Izmir, they have a very high number of zoning cases, and they also have regulatory supervisory authority related cases. So it may require specialization with regards to zoning and examination. And also the same applies to Izmir, that our colleagues who were coming from tax courts, they were not very much willing to specialize. Maybe they thought it could be a specialization with regards to customs taxes, but because I'm not an expert on this issue, I will leave it to Mr. Abdurrahman to consider. In conclusion, do we need specialization? Yes, we do, in terms of cases. And because administrative cases are actually acquire using classical methods, we need specialization. It is not possible for us to specialize in local courts. We have a couple of administrative cases, and it doesn't anyway cover variety of cases. They don't have these supreme boards or supreme authorities. They only cover the main target would be to ensure specialization in Ankara Administrative Court and maybe for Istanbul and Izmir Administrative Court. I believe I've been able to convey the main theme. Thank you very much for your attention.
So everything has been thought of. It was actually so prepared. We can immediately start this even today, but we all know that the real specialization from University of Wales, Madam Sarah Nason is going to be speaking on.
Thank you. Thank you, distinguished judges, coalition of administrative law chambers in England and Wales. I'm particularly grateful for this opportunity because England and Wales being a common law, colleagues from many jurisdictions over the years leads me to believe that we actually have more in common than divides us in terms of our administrative law, and that actually there's a lot that we can learn from each other. So this works very much both ways. It was interesting to hear earlier the mention in alternative dispute resolution of mechanisms in Australia and Canada, and also the discussion earlier about the role of the Council of State as a very important body in terms of developing general principles of good administration as part. So when I say we have more that is similar, I mean that actually much of the administrative law in England and Wales is statute-based, so it is in legislation. And that legislation will usually include an express route to redress within the administrative justice system. Most of that redress is actually through what we call a right of appeal to a tribunal since the 1950s to actually be an important and independent part of the machinery of justice rather than administration, and also introduced a body called the Council on Tribunals. And I found it interesting when looking at this, a distinguished professor writing at the time, Professor Wade, said that although it has emerged in the disputed territory between the legal and administrative worlds, which in other countries is the province of councils of state and administrative courts. But the major review that I want to talk about is one that took place in the early effective framework for decision-making, encouraging the systematic development of the area of law concerned and the introduction of a more coherent structure to the tribunals. It also focused on making sure that the tribunal proceed different administrative tribunals across England and Wales, dealing with nearly 1 million cases a year. The aim of the review was to rationalise and modernise the system, It was also to strengthen the independence from government users of the system, and also to innovate and consider alternative project that we're looking at here in Turkey. So these reforms, they were achieved through legislation, through something called the tribunals to provide judicial leadership. And it established the upper tribunal as a superior court of record. The senior president of tribunals within this system as well has a particular role to take into account when exercising their functions the need for to think about alternative dispute resolution mechanisms. So most of the existing tribunals in England and Wales were transferred into this new structure. I'll talk a bit about what of the older tribunals have been transferred into either the first tier or the upper tribunal. There are some tribunals that remain outside the employment tribunals, but in practice they are operationally integrated within that system. And there is a right of appeal in particularly complex areas. But there are also aspects of administrative justice that remain outside of the system, some key what that does. But in particular, the Planning Inspectorate sits outside of this system. The Planning Inspectorate is an executive agency of one local planning authorities in the UK. The Planning Inspectorate is dealing with planning appeals, 180 planning inspectors. If you take an appeal from a decision of a planning inspector, that would go to the Administrative Court, Specialist Planning Court, which I'll talk about later. And the first tier grew from 3 chambers on its establishment to currently who has been delegated the day-to-day management of their judicial and expert members by the senior president of tribunals. This is largely made by an independent judicial appointments commission, and that commission will look at statutory and non-statutory requirements around the specific post, as well as the general qualities that are required in any good law. The tribunal office holders are appointed to either the first tier tribunal or the upper tribunal, and then they are assigned to a particular chamber, for example, health, education, and social care. But they may or may not sit in all of the jurisdictions within that chamber, and a judge can sit in more than one chamber. I should also say, actually, the judges of the upper tribunal are appointed on the recommendation of the senior president, but they're ultimately appointed by the monarch within this system. There are also some other members that can be legal members of tribunals. So these could be, for example, members of the Institute of Trademark Attorneys or members of the Chartered Institute of non-judicial members with specialist expertise. So they may be medical professionals, surveyors, educational professionals. And requirements for those positions are based on the nature. The senior president has responsibility for the training, guidance, and welfare of the tribunal, judiciary, and the members. The tribunal and chamber presidents lead the jurisdiction of their tribunal or chamber. They take an active role in ensuring jurisprudential and practical consistency. Also lead the judges and members within their tribunal or chamber and are the first person that judges should turn to with welfare matters. Where a particular tribunal sits in panels of judges and members, the presidents will ensure that the approach to the panel composition is set requirements regarding recruitment and appointments, particularly in relation to what they might anticipate to be the caseload of that tribunal. So if we look at the members of this divided into upper tribunal members, first tier tribunal members, chamber presidents, and so on, we can see that there are 3,283 non-judicial members within the system as well. And if we look a little bit, one is a bit artificially low because of the impact of COVID-19, but still you see that the caseload there was around 305,000 in total. The high mental health, immigration, and asylum as big caseload areas. I want to suggest, for example, many adopt a more inquisitorial approach, an enabling procedure, such as the social security tribunals. Others may be more adversarial, such as tax and land, but legislation tribunal respectively. And legislation makes provisions around the content of those tribunal procedure rules, membership of a tribunal procedure rule-making committee, and also how that committee must exercise its functions. So the power to make these rules is exercised, or must be exercised, with a view to securing that and that where appropriate, the rules confer on the relevant tribunal members the responsibility for ensuring that proceedings are handled quickly and efficiently. And at the moment, there are 9 different sets of tribunal procedure rules. The committee, these are based on the chamber structure and the specialisms. And the committee meets very, very regularly, and it's online, for example. I'll come back to this one. So what this system has been designed to do is to try and seek a really balancing the costs, ensuring just outcomes, fair procedures, and accessibility. There was very little argument against reforming the system in the way that it had been reformed, that located this real benefit of tribunal justice in the specialization. A former president of the United States being their specialist expertise, their flexibility, and their tailored procedures. And the specialism is primarily based on subject matter, but there is also a functional specialization. So you see that the tiers primarily deal with, in the first tier, appellate, in the upper tier. Some of the specialisms are based around the identity of the litigant, so whether they are a young person, a military person, a victim of crime. There is also a geographical element, so with claims where there is a high and comparatively repetitive caseload like Social Security, these cases would normally be determined at regional centres, and there are 7 of those regional centres now across England and Wales. But actually, many of them will sit in other locations like business centres or hotels. Some of them even sit in university premises. Increasingly, a very large proportion of hearings in the tribunals are conducted online. I mean, it's already been said today that specialisation can promote just outcomes by fostering consistency in judicial decision-making, which is at the heart of the rule. The similar cases further concretises their knowledge, but the diversity of cases within the particular chamber and tribunal helps fill in the gaps in knowledge as well and improves their familiarity with overall administrative schemes. And of the realities of administrative decision-making, and the specialisation assists with that. It also assists with the development of expertise, and the presence of the non-legal expert members further enhances the appreciation of them beneficial, because consistency is really important. But consistency is also really important in tribunal. That is, to an extent, a court of case law. It's recognised as a superior court of record, and the senior president of tribunals comments on its role in laying down guidelines of law, principle, and practice on the issues to the specialist jurisdictions under its care. So it can assist the development of a coherent body of legislation across the Council of Europe countries is by the creation of specialist chambers or departments, and that's what the reform in England and Wales has tried to do, although it is a very large-scale reform. The tribunal and chamber presidents have really important roles in allocating judges and providing judicial leadership. The status of the special tribunal judiciary is ensured more than one tribunal, so they can develop their expertise and avoid the risks of compartmentalisation, also for the management of logistical matters. So clearly an argument against creating specialist courts or divisions is where a low volume of cases might make specialisation ineffectual. A small pie is inconvenient enough, but having to carve it into even smaller segments exacerbates the problem. So in this case, the very small pieces of pie, the very small jurisdictions, have been co-located with similar subject areas. And the upper tribunal, as that develops, needs to take care to preserve the expertise that it had on its formation, but to develop that further within what is a multi-jurisdictional structure. And I said it would also talk to courts, which are our first instance civil courts. There is then a high court, which is, it's a court of appeal for some cases, but for others it's the court of first instance. The King's Bench division, it goes back to the 12th century, and this was essentially where the decisions of bodies that were exercising administrative functions. So in the olden days that used to be lords and barons, but now it's local government and administrative bodies. And interestingly, historians have described the King's Bench as a supreme court of administration and argued that the absence in common law systems of a distinct body of administrative law, where proceedings against public bodies written of other common law countries, the USA, Canada, Australia actually have sort of followed a similar approach to this in terms of the development. But from the 1980s, and even a bit before that, these old-fashioned prerogative writs were harmonized together with other procedural exclusivity, so another means of specialization, to ensure that remedies against the unlawful acts and omissions of public bodies should generally be sought only via judicial review in the High Court, now the King's Bench Division. So that was to the Administrative Court. And from the perspective of specialization, it was said that idea of procedural exclusivity and specializing, concentrating many cases in various ways over the years, but by a list system of judges within the administrative court, so only certain judges with particular specialisms could be appointed to the administrative court. The reason there was a review of its efficiency as well, pending the incorporation of the European. Interestingly, there has only a few years ago been an independent review of administrative law disputes where it's named in the enabling leg 71 judges of the King's Bench Division, but not all of them would handle administrative court claims. I think about 45, 50 could do that. And the diagram here sort of shows some of the different jurisdictions within that. There's no separation of planning disputes. And public procurement cases, although not recognized as a separate court, they also have different procedures that apply there. But the administrative court can deal with quite a lot per year, which is in comparison to the tribunal system, which we're seeing has over 300,000. The administrative court has 4 regional centres, 3 in England and 1 in Wales. And interestingly, there was some argument against creating those regional centres when they were established in 2000 in oversight of the administrative state. But there hasn't been any evidence that the regional administrative courts perform any less effectively than the High Court in London. And judges are generally designated or allocated to determine claims in the administrative court. Administrative court judges can also be judges of the upper tribunal. Deputy High Court judges, who are often barristers with extensive expertise, can also hear claims in the administrative court. So there is a move referred to by the Judiciary and the Ministry of Justice as one judiciary. The process of specialization in administrative law has been based sometimes on developing the formal tier and chamber structure case to warrant the resourcing for that and for the judicial leadership. But on the other hand, developing areas of specialization might be addressed through procedural rules or just through administration, especially allocation of appropriately experienced judges. But there really is this move towards judges being able to sit in various subject areas and courts, depending on their experience. And this, I say, is referred to as one judiciary. The idea is to bring the courts and tribunals closer together. And the Lord Chief Justice of England and Wales and the Senior President of Tribunals have developed what they call a cross-deployment and assignment policy to allow judges to move between these jurisdictions. It's aimed to improve the ability to deploy judges with judges, and I think we expect further reforms on that in the future. I'll finish my presentation there, but I'd be very, very happy to take questions later on.
Çok teşekkür ediyoruz Sara Hanım'a.
Thank you very much, Madam Sarah. And now it is 3:10. Now we will have a coffee break until 3:30.
saygıdeğer misafirlerimiz, sempozyumumuzda
Distinguished guests, we will Mr. Hakan Öztetar. We now have the last two speakers, and now I'd like to leave the floor to the judge of the Administrative Court number 5 of Madrid from Spain to present her presentation on specialization at Spanish administrative justice system to Ms. Susana Abad Suarez. Thank you very much. It is a great pleasure being with you here. Distinguished ladies and gentlemen, I will be making a very brief presentation. And I will be talking about the situation it actually emerged in our country. I'd like to talk about the Spanish Constitution. According to this article in the Constitution, the courts are actually supervising the legality of the administrative action, and of course the public administration checks them to protect the rights of all the citizens and would prevent them from lacking any defense. But of course this is protected by law beforehand, and the main reason that the public administration abides by the law is to protect and defend the freedom of the individual. So the citizens and the public administrations are subject to the rest of the Constitution as indicated in Article 9 of the Constitution, which also means that also, in line with this law, within the public administration, all the laws confirm once again that in general, all the laws that are related, we do not only have one central government, we have different states here, and in addition to a central administration, we also have states. And among the autonomous states, again, we have the legislative power, and in these autonomous zones, it's not only the autonomous regions. In addition to their grouping, there are also historical, language or cultural joint elements as well, and they have their own legislative power, and that is why we also have an autonomous administration system. This does not mean that they are always bound. In addition to having an administrative state system, there are also certain points that are protected by the Constitution which fall under autonomous areas. What can they do? First of all, when implementing these regulations that are stipulated in a central manner, all the autonomous other states have to also abide by the general control. This does not only ensure that the public administrations are affiliated to the center, but they also ensure that they have their own laws and also local legislation as well. Looking at this from an administrative point of view, this points out to a quite complicated order, and this also leads to quite a lot of complications within our own judicial system, and also labor law is another one of these. And when you look at the labor law and the rights relating to this, we need to also look at this, and also within the criminal law, we need to also look at the control of the administrative law. And when we're talking about the judiciary, we're not only talking about by the administration, and they act according to the Constitution. Looking at this from this perspective and looking at the executive power, the different administrative zones decide on this, and what to do. The Spanish system and also the justice system is actually adopted from, and looking at its historical roots, we have not adopted this from the Roman system or the German system. Again, with regards to the separation of again giving the power to the administration, and Rousseau says that any right that is free is a right that has its own laws. So we are talking about laws that do not so the laws should have certain freedom. Control means that the control is at the administration with it. And again, we have the courts of appeal, and the regional courts help them as well. But then within the French system, for example, when we look at all the institutions within the public administrations, we see that they are actually based on more Western systems, based on French system. All the Western countries around France, we see that. And how is this distributed? The state actually says the final word, but of course that they have a great control power, and of course they are distributed to the administrations that I mentioned before. This is a Spanish system. We established this ourselves, but we can say that we've actually created a very complicated system with regards to the administrative system that we've adopted from the French system. And also among them, we have the high judges, and also university professors are included among them. This is a more complicated system, and looking at this complicated system, we see that there are administrative soon there are some other cases where there's no knowledge. There needs to be a certain revision, and all these administrative cases should be reviewed. We are not only looking at it from an economic perspective, but also within the Council of State. They need to control of all the public administration's actions are actually safeguarded both within the laws and also in the Constitution. In 1978 Constitution, these have been stipulated. And in order for us to further improve administrative justice, we had to ensure specialization, and both trade-related cases, criminal cases, labor cases, and military cases. We had to make improvements in that regard. And looking at it from the point of view of administrative justice, while organizing these issues, we had to exam, and then they take both a theoretical exam and a practical exam, and then they have to prove it throughout their legal practices as well. In addition to a central government, as I mentioned, we have the state governments as well, and they have to prove themselves with all the dimensions. Looking at it from an administrative point of view, they are the ones that are carrying out these jurisdiction, but looking at it from a legal point of view, when the public administration cannot resolve certain disputes, then in a way that would allow for different results and outcomes, but of course always to fall under the protection of the law, they ensure an outcome. The topic that we are talking about is having a margin of appreciation, and they have their own discretionary power, and using their own discretionary power, they can resolve these disputes which are stipulated in legislation. So in administrative dispute courts, they are actually regulated in the legislation. They are resolved by the administrative courts. And looking at outside the judiciary, there are also some political actions taken with regards to the executive power, and of course the public administrations and other administrators. They are acting as affiliated within a certain framework, looking at it from an executive power point of view, and this actually puts a line to the political actions of the public administrations. So certain political actions, I'd like to refer to them, some rights. These are the state, international issues, and of course, among them, there are certain political actions taken, and the state, within the general framework, try to resolve them from an administrative point of view. We always need to look at it within the judiciary. Of course, we're talking about a very political and which may be administrative as well. And also there are certain situations which may be relevant to cultural heritage, and there are issues that the state needs to resolve. And also among administrative situations, all the legislation and those that are stipulated in legislation and the law and their areas of practice are also listed. Of course, we have different pieces of legislation. Certain organs, legislative or executive organs, may have different considerations on how they need to be implemented, but within federal laws, they may have their own free areas. So this may be done directly in a certain procedure or by receiving information from a certain source. And looking at the laws, there's a certain administrative law, and this means that in a very concrete manner, will it be taken to the Court of Cassation or not? What is the topic? And they can verify this at this level. And also, we need to also look at certain regulations in that regard, which means that looking at it from a certain legislative perspective, these are controllable. And for that, the control is ensured by administrative dispute courts. This is the system in Spain. What they are controlling are what we call decrees in the force of law. The administration, of course, within certain limits, are following a control area of these regulations. When there is no topic that is stipulated by the Constitutional Court, then they can be taken to the Administrative Court. When there is any shift among them, or if there's a problem relating to legislative-related institutions, then the issue may be taken here. Of course, there could be certain deviations, and when we talk about norms within their own legislative internal arrangement, of course, they have their own special jurisdiction area. We're talking about first instance courts, and then afterwards we have the courts of appeal or second instance courts, and then we have third instance appeal courts, and we also have the national courts, which is that the first instance courts cover all kinds of topics, excluding administrative disputes, because they are already included in and separate in courts in the autonomous zones. And then if they are not resolved, they are taken to one higher instance court. If not, then they are taken to the third instance court of appeal. If not, then it is taken to the administrative dispute court, which means that we have a fund for this. Within the framework, within this legal framework, 80% of these cases are resolved in general at the appeal level, but there are certain cases that fall. Coordination is actually ensured among all the first instance courts with regards to the administrative court on inconsistency in case law. If to ensure equality among case law, they are and all these judicial organs need to develop a solution, and it is very important for them to have the same perspective on the same issues. Only through this they can protect apply the laws. And at the first instance courts, we have, when we exceed 30,000 euros in terms of amount, it is possible to apply to the courts of appeal and also higher judicial organs in autonomous regions. And then afterwards, how do we ensure coordination and cooperation among higher judicial organs, among the distribution of tasks? This is not at the crisis situations. For example, urbanization issue was included here, and on this issue there were a very high number of cases, and that is why we required specialization. And then afterwards, when we looked at the practice addressed, we made some different arrangements, which meant that within Spanish judicial organs, every area have their own presidents, and also the autonomous regions also have president. And we see that they are actually improving themselves, becoming more and more specialized over the years, and that means that they are gaining more specialization in certain judicial organs, and they may have provided some information, or may vary because the social conditions change.
En los tribunales contencioso administrativo, aproximadamente a día de hoy cada órgano.
And of course, amongst such topics that we deal with, there is a certain volume. Within this volume, we actually have the opportunity to observe this on an annual basis. In relation to the second effect, we cannot talk about a single zone in Madrid. We're talking about two different states of Spain, and all of these problems are actually resolved from an administrative center. This passes from certain qualifications and information, and this is valid for all of the Spanish courts. So what is our problem here? Actually, when we look at it from the courts that deal with such conflicts, what is the problem? The problem is actually there is a delay within the conflict resolution process, and there is lack of trust towards the judiciary, and the citizens might become victims. To work on it, they lose a lot of time. We are trying to resolve this over the course of years, and we have been working on these problems for a long period, but years pass to obtain information. And the end, when we look at this from the administrative perspective, there is a certain framework of time that is going to be needed to resolve it to the benefit of one party or the other. But of course, it has to be to the benefit of the citizen, and the exhaustion of all domestic remedies might take 1.5 to 2 years, which means that it is already too late. What could be the resolution to this problem? We have identified it in the following manner. Of course, the Spanish judicial system has the following, which is the mediation system. Mediation has been a problem, has been a solution for all of us. Within the Spanish state, mediation is not like in German in a compulsory manner, and this is how we have managed to adapt this. And of course, in relation to the resolution of such conflicts, we try to attain a settlement, and guiding us to mediation and mediated settlement. This is with the bar associations. And when there are topics of conflict with the administration, they can resolve this matter. And together again with the lawyers, bar associations, because they have practical information about mediation, this is suggested to us for an effective resolution. Within the bar associations, there is also an economic district. So we need to have a certain assessment, and within this assessment, we identify and assess the conditions. Amongst the conditions, we check whether we can reach a settlement with mediation, and this is again leading to an assessment on the judicial methods to follow. Normally, these are identified according to the value. We're talking about a value of up to 30,000 euros. And of course, this needs to be approved, whether there is a possible solution or not, or whether this gets individual approval. And likewise, this decision is a settlement with this mediation. They will have tie this up with a resolution, and this way the citizens will have witnessed the active resolution of these problems. And we look at the administrative system. The citizens do not feel themselves to have been heard, and this way we will have might be disappointed, and with this mediation system, they feel themselves to be more valued and heard. And by way of this, certain protocols, just like the Court of Cassation in Madrid, as well as the Court of Cassation in Barcelona, and also within the framework of the Council of Europe, and the legislation dating back to 1992. There is an alignment legislation in relation to the resolution of the conflicts, and when there are such is looking for a resolution within the Court of Cassation in Barcelona and Madrid, and within this organ, experience shows that in relation to financial issues or criminal issues, when we look at the success rate, their success is quite good. And what is the topic here? When we look at the various topics, of course, we will have taken this under a certain safeguard, and within this system, we can see the following. If they do not see this as a benefit to themselves in the mediation system, if that is the case, they can actually immediately cease the mediation process. But of course, when we look at the benefits for the individuals and the benefits for the administration, this shows us the following. We can identify certain criteria, and likewise, we can identify the areas of responsibility, and we take them under a certain safeguard. This is more or less what I wanted to talk to you about the Spanish system. Of course, resources are really important for us. We have not unlimited resources. We have certain, like this with the Bar Association, the issue has been resolved with the mediation service. Thank you. Thank you very much for this presentation. Of course, one process vis-a-vis the public administration, because they feel themselves valued, and this is attained by the mediation. The last speaker is the head of the chamber in Court in Council of State, a specialization in tax matters. Thank you very much, distinguished participants and distinguished colleagues. I would like to greet each and every one of you. Of course, this is the second day and the last session of a two-day symposium, and I'm the last speaker, and the topic is tax. Therefore, this is a topic which is not that sympathetic, and I do not want to risk the done and mentioned the various aspects. What is it and how is it different in relation to division of labor, and focusing on the tax the procedures, focusing on specialization, going to the roots, as well as its situation vis-a-vis the 19. What we understand from specialization is that it has a different structure and a different pool of expert personnel and complementified tax litigation. We have three alternatives. The first one is the current system, that is I'm talking about the post-1982 period. Within the administrative judiciary, the tax courts have become specialized courts, and they have been established as such and under this umbrella and dimension. and cases on tax litigation. And this is not a specialized judicial branch per se. Another alternative is amongst the types of tax like VAT or the special consumption tax, and it could be continued with the various Court of Appeal chambers and continued in relation to the chambers of the Council of State. Another and maybe an ideal solution, as our distinguished and it having its special structure. It's organized in that way in Germany, and it's a specialized branch of the judiciary and continues its activities as such. When we assess this from this perspective, of course, to see the practice in Turkey, actually, 22 period when the tax courts were established, going all the way to 1920s in relation to taxation. We have really immense examples of coming from practice. And this has come all the way up to 1980. Context, of course, what is important within the administrative judiciary before it became a specialized court, appeal process. When we look at the practice in the pre-1982 periods, so there were some appeal commissions, the arbitrators on customs tax. These were the institutions that reviewed the appeals. And at that point, we see a three-level litigation. You could resort to the Council of State vis-à-vis the judgment of the appeal commission. When we focus on specialization in tax litigation, it's important that we have a separate procedure for this process. And if, in that sense, the tax procedural law number 213, and in this code, there are a lot of provisions that regulate methods of ADR that have been included in the tax procedural code. Also, amongst such procedural code, after the accrual of the tax, the collection of the receivables and the revenue to be collected is actually regulated with law of receiving of the public debts dating 1953. And this is a separate procedural law that has been regulating this tax collection process since then. Both of these procedural laws are the primary resources. In the pre-1982 period, with the appeal commissions and with the appellate commissions covering the application to the Council of Tax. And this, apart from some of the decisions of this commission, there was an appeal commission, exceptions, but you could still resort to the Council of State. Therefore, there was a judicial review foreseen. During this period, but during the period where these commissions were actively working, the commissions and also were within the public administration were heavily criticized at that period and after that period as well. But despite all this criticism, both the appeal commission as well as the appellate commissions, these were actually the organs that initiated good practice here process. We passed on to the two-tier process, and amongst the administrative courts, the tax courts were established as courts were again identified in Article 6 of Law 2576, central organization. And apart from the generally authorized administrative courts, the tax courts were specially established. Again, they were responsible for the And then we started implementing in 2016 in the three-tier litigation. And once again, this tax courts were established as specialized courts, and the Court of Appeals have their that we can call experts or specialized reviewing tax cases, passing judgment on and they were reviewing some of the appealed case files ending in the resolution of the CAF. In addition to specialization until this point and the transformation and the change from this point on, we can focus on the German example. And I would like to make an assessment basing on this. The German example, especially in the field of tax litigation, is appearing before us as a good example. In Germany, before you litigate a case to the administration, objection to the administration, and if they cannot get any outcome as a result of this administrative objection, the taxpayers can make. In Germany, in addition to the ordinary judicial processes within the German system, there are branches of the judiciary. There's something which is also interesting in those. In those cases, there is a three-tier mechanism, but the procedure in the tax litigation is consisting of two tiers: the tax courts as the first instance court, and also the federal tax courts, which is dealing with the appeal process, and that's how the prosecution of such cases is finalized.
And also in these German tax courts, or the judges that are working in the federal tax court, when we look at their qualifications, we also see a specialized group of judges here, and especially the judges that are working in the tax courts in Germany, which means that both federal tax courts that work in the form of senates, and the judges that are working in the senates and also the federal tax courts work in the form. All of them should be of the profession and should have worked in the area of tax litigation. And a different practice in the German system is that the tax crime system, and they are actually not separated from other criminal acts. And we also have a similar, there is a separate court that is established in the first instance criminal. The collection of the tax receivables is not suspended when a court case is filed. This is also interesting, as we talked about when we're talking about specific procedure for trials. And although we have quite a lot of infrastructure necessary in terms of taxation within our own administrative judiciary, we try to carry out the litigation procedures relating to taxation bound by the rules that are applicable for administrative judiciary. But then administrative action, as a rule, the implementation or execution of these administrative actions are not suspended. For them to be suspended, there should be a request made to the court, and this should be accepted. In Germany, in UK, in France, there are similar practices, and this also applies to tax. Automatically, collection of the taxes is not suspended. For that, you need to put in a request to the court, and the court should approve this. However, in Turkey, we have the quite opposite situation. According to Article 27 of the law number 2575, filing a case at the tax court automatically suspends collection of that tax. And from this, you can also derive the following meaning: administrative actions are tax-related cases. You may also say that taxation actions are completely different from administrative actions, and they are subject to completely different procedures, and they're not very much explanatory, but this is the procedure which is applied. And again, in the German practice at the federal court, there's a very good example. The judgments of the federal court are final. However, they are binding on the German Ministry of Finance, and they are guiding the practices of the German Ministry of Finance. This is also interesting. The German Ministry of Finance, especially when they see have those judgments abolished, but however, despite these initiatives, if they still persist, the German Ministry of Finance undertakes the necessary work and to make the necessary legislative changes, the German to be made in the legislation, they do so according to the judgment of the Federal Court. Looking at the practice, this similar practice in Turkey, when we look at the older periods, which we may call 25 or 30 years ago, and we have our colleagues who can be considered to be masters in the techniques of the Council of State, when they are consistent, they are always taken into account by the taxation administration or the finance administration, and they publish the relevant communiques or directives, and they use today as well, and it should continue. However, with regards to their case law, so that they will be taken seriously by the Ministry of Finance and they are implemented. Looking at the practices in our country, we see that I will talk about very briefly the historical stages in administrative justice and also the tax-related judicial system. And after talking about country examples, I'd like to present some suggestions. As I mentioned, the objection to taxation, to a public administration, is only relevant to customs authority. You cannot directly file a case against the accrual of a customs tax. First of all, you need to file an objection to the customs authority. Other than that, against all taxation, however, in our country, this issue of directly filing a case at the court, even though if it is optional, does not mean that the procedure of objecting to the public administration is not being applied, especially following the implementation of Article 11 of Law Number 2575. And actually, this has become a consistent practice through the judgments of the court, because in the past, the taxation-related matters were excluded from the scope of this article. However, after it has been changed through the judgments of the court, according to Article 11, it is possible for the individuals to apply to the public administration for the action regarding them to be reversed, cancelled, or changed, and again, according to the deadline of filing a court case, which had already been in the pre-1982 period, especially in the period where the objection commissions and appeal commissions were in force. And actually, as I mentioned before, starting when we look at the working procedures and principles of these commissions, to be able to understand specialization today, or to be able to see what we have neglected or what we failed to see commissions or appeal commissions, when we look at the procedures and principle that they were considering in reviewing these cases, we see that they are one-to-one similar to the working procedures and principles of the courts of appeal, which were introduced in 2016. And also, when we look at the precedent of these, because in 1982, when the sub-courts under administrative judiciary were being established, or rather more correctly, the tax courts that were recently established already had institutional memory, they already formed. However, especially after the tax courts, which were established in 1982 as specialized courts, a temporary article was inserted into the same law, and this provision, economy, finance, etc., as long as they are graduates from this, then the Deputy Director General of Ministry of Finance, or accounts experts, or inspectors, it would be possible for them to be assigned as presidents and members in these tax courts that were established in 1982, which were established as specialized courts. And after these tax courts became operational, after being established in this way, without causing any interruption, the following period, was it possible to now? Unfortunately, we see that the same practices were not maintained. So the well-trained personnel who are specialized in the area of taxation in taxation judiciary, who were actually well qualified, and they have been assigned to work in the tax courts, and we have witnessed criticisms against them as if they have become judges overnight. However, also as a judge who has worked in these tax courts and have worked colleagues, that even if you were to lose the text of the period before 1982, the president and the members of the commissions that were working with regards to objections and appeals against taxation matters, it may be criticized that they did not have the qualifications of acting as members of judiciary. However, after the establishment of the tax courts, having them assigned there to work as president and members of the courts should have been considered as an organized people take part in tax courts. And today we see that the members and the judges who are working in the tax courts are working as if they are the same judges, or they are being assigned from the same pool of judges where other judges to other general courts are being appointed. And then you see that one person who is appointed in a tax court is then appointed to another administrative court, or we see and witness a judge who had formerly been appointed in one administrative court then being appointed to tax courts. So as an opportunity, this specialization opportunity which emerged in 1982 were actually put in the shadows by such practices which prevented specialization. And also with regards to specialization in tax litigation, not only in terms of tax courts, but when we look at the period before 2006, after the introduction of the Courts of Appeal in 2016, we now have the tax chambers that are also taxation matters. But this kind of classification is not a specialization in a technical sense of the a difference in an inconsistency in case law. And as a result of these practices of different appointments, you see that there are some appeal cases that are received at the Council of State from 2-3 different chambers of the Court of Appeal may fall under the jurisdiction of different chambers. Okay, I'm running out of time and I will wrap up, and I'd like to talk about our suggestions now. Yes, all the work that requires specialization or transition or any kind of an attempt of improving the system should start at the faculties of law. And tax law and tax litigation should definitely be included in the curriculum of the faculties of law as important subjects, and the same importance should be also attached to their representatives, the bar associations. We believe they can also provide significant contributions in this sense. I have just mentioned how the German Ministry of Finance has certain practices on the basis to implement the judgments, the consistent judgments and case law of the Council of State in the area of taxation, and also in terms of recruitment into profession, and also in the recruitment of candidates to the profession. The judges who be provided a separate training if possible, and if necessary their examination should also be held separately. Another suggestion, as Mr. Minister also indicated in his opening remarks, according to, especially in 2022, the total number of cases in tax cases is 130,000, and around 60 or 70% of them are in among themselves establishing a separate judicial system for taxation, cassation or higher level court. This is not very practical in our country right now, but then in jurisdictions, according to the division of tasks judgment of the Council of State, For example, with regards to property taxes or stamp taxes that fall under certain areas of work of Council of State, or customs taxes, which are, and then their courts of appeal or the chambers at the Council of State dealing with these cases may be also separated. And one final remark could be regarding the following, especially in our tax procedure law, the mechanism of conciliation or administrative objection, which allow for the disputes to be resolved before resorting to the judiciary. Those kind of mechanisms should be rendered more effective. And also in our procedural laws, we have correction and complaint mechanism. And also, according to Article 10 of the law number 2577, and a request to be to have those taxation matters, taxation action nullified. I would like to thank you very much for listening to me with attention at the end of this very long. And I'd like to say thank you for Özlem Bölükbaşı, Yelda Ayazma, Adis Ayana, and Semih Belen very much. And now we will start with the questions and answers session. If those asking the questions could please indicate the addressee of the question. To the left side, please.
Up to this point, in relation to specialization, what have been the obstacles before the special tax judiciary? Thank you very much for this question. Actually, the obstacles before us in relation to specialization are stemming more from the practice. After 1982, when the tax courts were established under administrative judiciary, there is no legal provision that eliminates further specialization in tax judiciary, but there was a background that was coming back from the past, an institutional tax litigation. Especially after 1982, taking into consideration all of these, practice could have guided us further developing this after this point, and it could have been even brought to the level of the good German example, having a specific tax judiciary system. We had this opportunity, but I'm not talking about the last 10, 15 years, but although they were needed to be courts that were kept in a special place under administrative judiciary, they were treated like stepchildren. And people who did not have anything to do with tax were appointed to tax courts. They were appointed as inspection. Talk about the problems stemming totally from the practice. In time, these problems led us to lose this trained personnel. Maybe we can retrain the personnel and revive them. Thank you. First and foremost, I would like to thank all the distinguished participants and the speakers. I am a reporter judge and more or less like a stepchild. Maybe this is the reason why we're here. We look at the procedure code for the criminal sphere. We see 350 articles. Again, the tax procedure code. Talk about specialization, but this is especially a question to Mr. Bülent Küfüdür. Can we actually get specialization with this infrastructure? Especially after the appointments, we believe that there are many people appointed to Istanbul, Ankara. Here, as the active public administrations, they are mostly in Istanbul and Ankara. And let's think that we also achieve specialization. How are we going to attain specialization in the Court of Appeals? Will we have sufficient number of Court of Appeals? Because we have different Court of Appeals at different areas. How are we going to establish this unity? So if we can get an answer to this question. During my presentation, I uttered the following sentence. In relation to procedure, we need to have legal amendments in the legislation. Yes, the law of the Council of State. This needs to be reviewed, changing the qualification for parties and many articles that are now outdated. Maybe it's not important for specialization, but we still need some further provisions. The way these specialized courts work, there are cases that are going to be referred to the Court of Appeals or to the Council of State, but Law 2577 needs a general amendment. Established, we added provisional articles to 2577, 2576, and 2575. After the Court of Appeals have been established, we actually implement many things in practice by a judgment of the Council of the Presidents. But in relation to specialization, we actually do not going to get specialization in the regional admin court. They already have a certain specialization. They do work. It's not full specialization, but when we have but in the first instance, the rapporteur judges who have worked in the Council of State or experts in this area might be insufficient. That's why we believe that we should start from specialization in Ankara Regional Administrative Court. This is important because doing our activity both in Ankara, Court of Appeals will actually meet its own resources from colleagues who have been trained in the first instance courts. But for 2577, I do believe that we have a provision and there were different actors, and that's why it was not implemented. Thank you. Halim Alperen Çıtak. I'm a member of faculty of Hacı Bayram Veli University. My question is going to be to Ms. Sarah. In the beginning, mid-19th century, there were certain criticisms. You indicated that the King's Bench division dates back to 12th century in terms of didn't Dicey see this? And secondly, in connection with this, my question is as follows. In the UK, the current situation, the fact that there are separate tribunals and that there are non-lawyer or non-jurist members, does this not mean that they have also adopted this administrative system? So
shall I answer that? No.
Evet, öncelikle sunumlar nedeniyle
first of all, I would like to thank you for your presentation. I also have a question to Dr. Sarah. In many countries of the world, of course, there are judges who are not coming from the law background, and this is also valid for our country. But in our case, those judges who are not coming from courses on law, and of course, they receive a formation training for law. But in your country, you have shared a table with us. You are talking about 5,000 judges, 3,000 are non-law, 1,700 if no legal training. They are also acting as judges. Does this create problems in the system? Could you please elaborate on this?
Yes, thank you very much. In England and Wales is described as something of a dark ages for administrative law. And the constitutional scholar Dicey is taken as being quite critical of the idea of having a separate administrative law with separate principles. It goes, I suppose, to the alternate argument against specialization is that there is significant value to judges being generalists that there's a strong ethic of generalism, even across Council of Europe, many Council of Europe states, the idea of law across all areas. So Dicey's criticism, I think, of creating a separate sort of administrative law was in part around this. It was the idea that you risk losing some of the specialization that some of the generalization, which is actually in itself very powerful. But he was also, I think, writing at a particular time, and there are many different interpretations of Dicey's work, and some very much associate him with the idea of the strength of a parliament and the idea that a parliament is a body that speaks with one voice, and a concern about the power of the judiciary and particularly a kind of specialist administrative judiciary to challenge the power of a parliament that was taken at that time to be sort of speaking at one voice. There are others who don't think that Dicey was being as critical of separate administrative law as some interpretations. There are quotations from Dicey and work from Dicey that talks about the tribunal structure that was developing at that time and starts to recognize the valuable context. I think the question in terms of specialists within tribunals who are not, they're not judges. The point to make here is that they're not members of the judiciary. So they are appointed as tribunal members, and they sit within the tribunals and they advise the judges, and they are there to provide specialist expertise on very complicated matters that might relate to medicine or might relate to sort of surveying and planning and zoning issues, but they aren't members of the judiciary in that sense. So you would not find cases that would be determined without a judicial member involved in that panel. So all of the judicial members have expertise in law as practicing barristers or solicitors or other forms of legal professionals. And in order to be appointed to the upper tribunal, the higher tribunal, they have to have very extensive legal expertise. So the members are not there to make decisions on points of law. They're there to provide their specialist expertise, and we find that system helps to improve the efficiency of decision making and the effectiveness of that process as well.
Evet. Bir soru var herhalde ama buyurun. Son olarak
Last question, because it's already 10 to 5 and we will have to come to the end of this third session. Last question, please. And Abdullah, I would like to ask this question to Mr. Abdullah about the tax criminal courts. On the same act, if there is a tax misdemeanor and a tax fraud, this is a dual litigation process, the prosecution process, and from time to time the judgment of the criminal court and the tax court might be in contradiction with each other. And this is also in one of the Constitutional Court judgments having harmed the legal safeguard principle. And in the doctrine, almost in all articles and theses, the tax criminal courts are indicated that it's necessary to establish tax criminal courts. What is your opinion in terms of establishing tax criminal courts? And also, are there any concrete steps to establish this, any legal provision or anything like that for the establishment of tax criminal courts? Thank you very much for your question. I don't know whether there is any preparation for a legal draft. But when I was making the presentation, I specifically mentioned, I can't remember the name of the or the date of the decision, but with the decision of the Council of Judges and Prosecutors in relation to tax criminal offenses. In certain areas, there were specialized courts that are established, and they are now operational. Yes, in the judgment of the Constitutional Court, especially after the last annulment, the fact that the tax criminal offenses are effective, the connection, the interpretation that severes the link becomes even more important with the establishment of such courts, because under the law and misdemeanors, the fact that they are working as specialized courts on tax and criminal offenses is meaningful. But even that, in relation to the tax penalties, the fact that they are effective on each other is not going to eliminate this confusion. And we shall be seeing this with the practice, because until this point, before the establishment of these specialized courts, or by way of a legal expert opinion, like a chartered accountant, but the tax court judgments were not awaited. This was the tendency, but after the recent annulment decision of the Constitutional Court, we will see how the practice shall evolve. Thank you very much. And we would like to end this session here, of course, for 2 days. We really had very valuable presentations, and hopefully there will be a book prepared from this 2-day symposium, and we will be providing benefit to everybody through this 2-day international symposium. Once again, welcome. Thank you very much, Mr. Sotar, for moderating this session. We now have a ceremony for presenting the token of appreciation to our 3 distinguished speakers, and Director General of Legal Affairs, the moderator, Mr. Hakan Sotar, to receive his token of appreciation. Susan Suarez from Madrid, the 5th Administrative Chamber. And President of the Ankara Regional Administrative Court, Mr. Bülent Küfüdür. Mr. Açıkız, we would like you to wait in the restroom for a little while, and I would like to invite the Deputy President of the Council of State to deliver the tokens of appreciation for the other 2 speakers of this session. From Galler Bangkok University, Dr. Sarah Nazan, please. And also Head of Chamber, Mr. Abdurrahman Gençbay from the Council of State, to receive his token of appreciation, please. Again, we will have a family photo of this session, and invite you once again to the front of the rostrum.
Çok teşekkür ediyoruz sizlere. Sempozyumumuzda artık genel değer
Thank you very much. Now we have reached the overall assessment and wrap-up section of our symposium. 2 rapporteurs will provide an overall assessment. Dr. Sarah Nason, Senior Lecturer in Administrative Law and Jurisprudence from Bangor University, Wales. She will remain here, and we can maybe ask the other speakers to take their seats among the participants. Thank you very much. Ms. Nason will University. You are kindly invited. So the 2 rapporteurs, after providing their overall assessment, when it is completed, I will then invite Mr. Birmingham for the closing remarks. Thank you very much.
Well, many thanks everybody for topics for the future of this for this project, and also for administrative justice in Turkey and how important and valuable everything we've discussed is. And we would obviously like to thank every single one of the contributors. From my perspective, my contribution now really is just to talk to you about how we will be producing a report of the proceedings of this symposium as part of our next steps for the project. So myself and my colleagues will be working on producing that for you, which will include a copy of many of the speeches, and alongside that we'll be introducing some of those issues and also drawing conclusions on that. So I'm not going to say any more really today about the symposium overall, just to say that we'd be delighted to produce that report and collection of proceedings for you all, and we hope that you'll find that very valuable and useful in the future.
Participants, first of all, I would like to emphasize that we have reached the end of a very important project, and I'd like to avail myself of this opportunity to thank all the stakeholders of this project and everyone who contributed with their efforts. Under the symposium, very important topics have been addressed. First of all, we talked about consistency in judicial decisions, and administrative justice is separated from other fields of law because it is based on jurisprudence, so that is why ensuring consistency in judicial decisions is of very great importance for us. And I would like to especially provide an assessment on the basis of the preventive mechanism, the jurisconsult that is established to prevent inconsistencies among jurisprudence of the European Court of Human Rights. And jurisconsult is actually a department that serves as the memory of the European Court of Human Rights. Maybe this could also open up an avenue for the Turkish judiciary as well. As you know, we also have the prosecutor's office, and 1982 it was actually a spokesperson of the law. And in France, we also have the rapporteur public in France, and in the issue of maybe reinstating this mechanism could be considered. And also with regards to elimination and prevention of being made is that in Turkish law, in our current system of law, we have mechanisms that could help eliminate inconsistencies in case law. However, in terms of mechanisms that could prevent them before they emerge, we see that this is an effect as well. The mechanism of unification of case law, and I'd like to refer to Lütfü Duran, and actually two works by Lütfü Duran after the reform in 82. He had a very good article saying that administrative judiciary has become ordinary justice, and we need to maybe go back to the issue pointed out by Lütfü Duran and rethink the situation, because administrative justice is much intertwined with the public administrations, of course, without losing its independence and impartiality. So we need to maybe think about what had existed before 82, what we have lost and what we have gained. Maybe we need to think about this as actually underlined by Mr. Abdurrahman. Maybe the workshop, but it might be necessary to address this, or the group of cases or the series of cases that we see in the French system being implemented. They can also be implemented in Turkey to ensure a justice system in mid-19th century feels the requirement to continue the complexes that the French system had in that period, cancellations or suspensions. And I think that this attitude cannot be maintained. This injunction issue, which was only specific to the Anglo-Saxon system, are now here, needs to be also adopted to ensure functionality of administrative justice, because such kind of a judge that is only ruling in terms of cancellations, then that judge is actually a judge that is coming short. And when the public administrations are not giving any instructions, they do not fully implement the judgment, or they do not understand the judgment, and this keeps increasing the number of disputes. There are two last aspects that I'd like to underline. The first thing is that in the administrative procedure law, civil procedure law, in terms of the issues where there's a reference to the civil procedure law. This was already discussed at the workshop, and I wanted to raise this once again. And also the administrative duties of the Council of State that are regulatory actions that go through the review of the Council of State would have a lower possibility of giving rise to disputes later on. Thank you very much. These were my overall assessments. We would like to thank Ms. Nazan and Mr. Çıtak very much for a closing assessment. We will be now leaving the floor to, first of all, the Council of Europe international expert, Mr. Ray Birmingham, who contributed a lot since the beginning of the project. You're kindly invited to the rostrum, sir.
Thank you all for staying until the end. The first thing to say is don't worry, I'll only be speaking for 10 minutes or so, and then so our distinguished academic colleagues have described how as a legacy document, the report of this symposium will be produced. I'd like to do two things really. Firstly is quickly describe the strategic framework within which reform of the administrative justice system in Turkey for the reform of the system which we started speaking about yesterday. Firstly, on a personal note, I'd like to say I've been working on this project since the start. I've been involved in the in-depth assessment, and I have relied very heavily on the cooperation and expertise of colleagues in this room now, and a valuable contribution the pilot courts around Turkey have produced, the support they have been given by their regional presidents, and to the Ombudsman institution. Everybody has been extremely helpful to us. We are interested in specific and concrete results of reform processes and in identifying and sharing best practices. So I'd like to draw attention to the first one of those is the very recently published Manual on Good Administration Principles produced by the Ombudsman institution. International experts have looked at that and have been extremely impressed by the quality of that document. And those of you who are new to the legal profession, I commend that to you as a valuable document. And I'll just read an extract from the introduction by the Chief Ombudsman, who reminds us all that it should always be remembered that good administration is a right of the citizen, while it is an obligation of the administration to be resolved by good administration and good internal review by the administration. The second initiative I'd like to refer to is the decision writing guide that has been produced by the Danish DAI and that has been implemented within the Danish DAI and shared with other colleagues. It's been talked about during the training modules that we have organised, and I know within the Danish DAI. And thirdly, I'd like to give credit to, yesterday we heard about all the work that the case law statistics and reporting unit of the Danish DAI have been doing in these last few years. That's been extremely impressive work. In the strategic context, there are two current documents to be aware of. The first is the current judicial reform strategy for Turkey. It's called Vision 2023, towards a trustworthy and accessible justice system. And we can expect, I would guess, a new judicial reform strategy later this year. There are a few supporting objectives of that strategy that I'd like to mention. First is improving and developing a people-oriented service approach within the administrative courts. Secondly, more effective protection of human rights and freedoms in the operation of the administrative courts. And thirdly, improving judicial independence and impartiality. Now, that strategy covers the whole of the Turkish justice system, but there are a number of elements that directly relate to the administrative courts. The second important document is creating a stronger system to protect human rights, to strengthen judicial independence and the right to a fair trial, and promoting a high-level administrative and social awareness of human rights. Now, that contains specific proposals in relation to the administrative courts. For example, the move towards specialisation has started. I met with the Council of Judges and Prosecutors just a month ago, and they're still working on the detail of that. There are a number of considerations, not least the impact that kind of specialisation has on judicial career paths, and the issues about just effectively managing the workload that arises when you specialise courts. It is on the table outside. It was described yesterday as a living document, and we are publishing and consulting now on an updated roadmap, which we hope will influence the new strategic planning. It concerns the continued work on initiatives that are in the existing plan that haven't yet been implemented. So, for example, as Nilay Hoca mentioned, we were waiting for some reforms of the Peace Commission's Decree Law 659. I know amended regulations are in draft and are being consulted upon at the moment, so we await news of that. There is a strategic objective to produce a group case. 12 or 13,000 cases that went into the administrative courts could have been resolved if a pilot case procedure was existed and a single leading decision was taken that resolved the issue that created that entire category of cases. So we hope that that will appear in the updated strategy. Simplification of fees and costs is also in the existing strategic plan. We're still waiting for news about and so on. So we hope that the simplification process will also review the affordability of fees and costs. Next, there are a whole range of proposals relating to the professional capacity and the continuous professional development of the judiciary that are still being worked upon. And we have seen in this room over and investment in you as the most important resource available to the administrative courts is important for the future, and we hope that it continues to be a priority in the Turkish system. One issue that a single judge, which as you all know, there are certain monetary limits that determine whether a single judge is appropriate to hear a case. Questions have been raised about whether there are any efficiency gains from that, whether it's generating unnecessary appeals, and there seems to be a significant number of single judge cases being overturned. Criterion for measuring the significance of a case. So we hope that further review of the system of that single judge approach will look quite widely at the operation of that so far and possible alternative criteria that could be used if the single judge is going to be maintained. New policy that we would, the last couple of days, we see a strong case for an administrative procedure law, and I don't need to say any more about that. We see a strong model of deemed acceptance. What they did in France was have a very cautious pilot with a small number of administrative case types, and then they conducted a post-implementation review to see whether it was appropriate to be extended. If Turkey proceeds down that road, perhaps a cautious pilot exercise is the way to start. The power for ex officio investigations to be conducted and for the Ombudsman Institution to be able to conduct thematic reports where the Ombudsman is seeing patterns of poor practice in the public administration. We see this, it's recently been mentioned, we see a strong case for holistic review of Law 2577 for the reasons that have been described in this room this afternoon, and we have seen issues. So, as has been said earlier, there are a relatively small number of articles compared, for example, with the civil procedure law, and that produces vagueness and incoherence. We'd also like to see pre-legislative impact assessments because we have seen really consulted as they might have been, and that has negatively impacted upon the efficiency of the operation of the courts. Will be certain activities to ensure the sustainability of the activities the project has been working on. For example, we'd like to see all those hard copy documents that are on the tables outside, we would like to see those available online. We have made some recommendations concerning the quality of the annual activity reports that the regional administrative courts produce at the moment. We think it's like that. So we're consulting the Ministry of Justice at the moment with an updated roadmap, and we hope that will be a valuable legacy document, and we hope it will influence the development of strategic plans covering the 2023-26 period. So thank you for your attention.
Sayın Ray Birmingham.
I would like to thank Mr. Ray Birmingham. Secretary General Kemal Açıkgöz to the rostrum, please. The international expert of the Council of Europe, Mr. Ray Birmingham, will be receiving his token of appreciation for his contribution. From Veli University. Thank you very much to each and every one of you for your contribution. And now the closing remarks of the symposium are from Christophe Porel, the Human Rights Director of the Council of Europe. He's not amongst us, but this is a video message that Mr. Porel has sent to us.
Distinguished participants, ladies, on the administrative justice in Turkey, which provided a valuable forum, I believe, to exchange on the best national and international practices to support the Turkish authorities in the reform of the country's administrative justice system. By addressing critical topics such as consistency in judicial decision-making, helped you to gain insight that can lead the way forward. Other legal systems across Europe have undergone significant reforms of their administrative justice systems, and we know that this is not an easy thing. Such reforms usually aim at making the system more effective and efficient and require a broad scope of legal and practical measures. For any out of law, This is what our European family of nations is based on, what unites us: fundamental rights as the basis for democratic security on the continent. Making this real is a continuing process, of course. Human rights are not values that are secured once and for all. The challenges and setbacks on this journey give rise to lessons learned, and they offer also opportunities for advancement. On this, it has served European citizens well. But while the European machinery is fundamental, it is at the national level, with you, that the most significant powers of human rights protection lie. The principle of subsidiarity clearly places national judicial authorities at the heart of protecting the rights and freedoms of people under their jurisdiction. This requires continuous attention by national authorities. It entails, of course, a multifaceted and complex process where numerous national institutions and actors have to be engaged. As of the administrative judiciary and strengthening the institutional capacity of the Council of State, in the framework of which this event has been organized, we aim to foster public confidence in the administrative judiciary, to make progress with all of you, our partners. Specific objectives to support further reform of the administrative justice system include strengthening the institutional capacity of the Council of State and to increase the quality and effectiveness of the administrative justice courts. As we all know, this particular project will end quite soon, on 20 March this year. We are looking forward to continuing our fruitful cooperation, and I hope the outcomes of this symposium will be taken up by our partners effectively as possible. It is in this spirit that I would like to express my most sincere gratitude to the Ministry of Justice and the Council of State for our very good cooperation. The Council of Europe is committed to supporting all efforts that genuinely aim at ensuring human rights. This takes notably the form of cooperation projects, the operation of which would be impossible without the support of the European Union board. Our respective institutions not only share a flag, but they are built on the same fundamental value and are working hand in hand on a daily basis to promote those values. I would like to close by thanking you all, distinguished partners, participants, experts and moderators, for your important contributions to this symposium, without forgetting, if you would allow me, my colleagues in Ankara, having our common European values. I thank you for your attention and wish you all the best in the new year.
Sayın Poirel'e de teşekkür ediyoruz.
We would like to thank Mr. Poirel for organized under the project on enhancing the effectiveness of the administrative judiciary and enhancing the institutional capacity of the Council of State. For 2 days, we have listened to very beneficial and very contributive remarks. We would like to thank all the distinguished participants, and we would like to thank you for your patience. And ladies and gentlemen, good evening.